they did not allow. And again issued a notice, my lord, only, my lord, that the intention of the authorities is, my lord, only to harass the petitioner during the ensuing election, because the investigation was launched in the year 2023, my lord. And your lordship kindly consider, after declaration of the election, from 2nd April, they, my lord, issuing the notice. So your lordship kindly, my lord, tomorrow, my lord, your lordship kindly fix it.
Tomorrow? Within 10 minutes.
One indulgence, my lord. Your lordship kindly fix it at top, otherwise, my lord.
Within 10 minutes.
I'm grateful to your lordship. I'm grateful to
Election Commission issued a notification to 6 to 6. And 6 to 6. 6 subject to lordship, central of your lordship, take it up. Central of your lordship, your lordship, notice to them.
Today it is not possible. But may I have tomorrow? Tomorrow and today, how it can be? Because tomorrow you come, I will take. Tomorrow if the other side will come, I will take. You granted. जितना भी unlisted है सब first आएगा, serially आएगा, then उसका बस. May I have it? The matter.
Faulty affidavit filed by one of the candidate, analogous matter today,
What?
Because analogous matter fixed today.
Maybe let me see what already one matter is already disposed of by this court, dismissing the writ petition. Writ petition is not maintainable. So today is fixed. In the other case, today is fixed for satisfying this court. Let me see what they are satisfying, because
Tomorrow.
But seeking lordship's leave, here the petitioner before lordship is a government employee who was murdered. A form which was given, form which was successful, should transferred. Now the asylum process came, draft roll, her name was there, her parents were in last asylum.
what is your prayer? So go to the appellate authority.
Election Commission advised me to Form 6. Accordingly, I was given Form 6, which was not rejected for insufficient.
That 6 is rejected. Go to the appellate authority. You have the writ petition. Can you see the Supreme Court has already directed? Then you go to the appellate authority, file the appeal before the appellate authority.
Possibly, if I'm not wrong, from appeal, I can go to the tribunal. But here, my case is
What relief you want before this from this?
Form 6 was rejected for.
So Form 6 is rejected. You not preferred an appeal before the election of the district election officer preferred an appeal. We preferred an appeal before the district election officer against the order of the electoral officer. Then what the court will do in the T226?
The petition.
You preferred an appeal. You are not preferred to go to the arbitral tribunal. You are telling is the appeal which date? If you are not prepared to appeal, what the court will do? You go and prefer. Invoke 142, go. Yes.
One matter last week I mentioned is a gun license, my lord, and my lord fixed the matter on top, but not appearing. Let it be tomorrow or Monday, my lord. This is a very urgent matter.
You are an advocate.
Yes, ma'am.
You know how to read and write the English. You know how to read and write the English.
Yes.
Have you read the cause title of the cause list?
Today.
Yes, read. Read the cause title of the cause list. Yes, call the list.
Your Lordship,
My lord,
may
I'm
please
seeking-
mention a matter.
I'm seeking for kind leave, my lord.
Call the list, call the list.
I appear for the response.
The repetition is dismissed, can is allowed, stay is vacated.
Gratefully.
Yes.
My lord, I am for the petitioner, my lord. My lord, there's my instruction, my lord.
The matter is listed as to be mentioned on the prayer made by the counsel for the petitioner. Counsel for the petitioner handed over the written instruction from the petitioner and submit that the petitioner is not intending to proceed with the matter and press for withdrawal of the present writ application. Considering the submission made by the counsel for the petitioner and the written instruction, WPA number 4990 of 2025 is dismissed as withdrawn. Entry modified and stand vacated. Written instruction be kept in the record. Next.
Grateful.
Item number
Your Lordship,
3 to 6.
Your Lordship, I appear for the respondent, the Election Commission of India. Your Lordship, I am led by my senior, Mr. Chaudhary, who is currently engaged in court number 12.
What is the order of the division bench?
My lord, I appear.
The order copy.
My lord, I appear for the petition.
See the order stay, then what? How? Why the court will?
We have gone through the order.
Hmm.
And I will place in my case.
ना किसको लगो
Yes.
I appear for the petition.
What is your case?
But my case in short is petition item number 6. But my case in very short is that I am an associate professor, but called for the duty for the first phase of training. I did not attend. Show cause issue, I replied. Show cause, giving all the details and memoranda. Show cause issued to me. I replied to the show cause. Number one, show cause issued to me. My reply is not taken into account. No whisper. Mechanically show cause issues. Thousands of show causes. I replied to the show cause also. After I replied to the show cause, my lord, nothing done. I come up before the honorable court. Yesterday, but after the honorable division bench, second show training has been issued to me for today. I believe my client is attending. That is the position. But my case is in sum and substance, well, in paragraph 7 of this order, Lordship will find. Paragraph 7 of the division bench order, Lordship will find the case of the summons of the allegation and the writ petition has been stated out in that appeal. My case is similar that I am an associate professor. Senior Lordship's order, Lordship has held that the 2023 circular in the subject matter is referred to previous circulars, but are not referred to the 2010 circular. So therefore, that is still in subsistence. So therefore, assistant or an associate professor has to be represented as a micro observer, not a president. That is your lordship's rationale. Now, my lord, that is my case. But if your lordship now, this division bench has passed an order. My lord, if your lordship takes the order of the division bench, my lord kindly takes paragraph 33. 33 থেকে 35 এ যাও বুঝতেই পারছি না তো আরে কি করছিস ভাই খোল
Yes. 33. Yes.
kindly just give me 1 second.
32, sure, 33. My lord, I'm sorry. To 33 deals with the 2010 and 23 circulars. I
Correct.
just referred.
Correct.
My lord, kindly takes 35.
30.
Paragraph 35. My lord, paragraph 35. My lord, deals with the intervening applications by the candidate whose petition is also appealing before Lordship, that intervening in the appeal. And my lord, kindly now sees Mr. Bhattacharya, learned counsel, for sought to intervene in the proceedings. The said intervener is a teacher of such and such college who is agreed with the appointment as the presiding officer and is further agreed with the show cause notice because the intervener failed to attend. Well, my case is similar. A separate writ petition has already been filed by the intervener challenging the show cause notice that I have done, and we are not inclined to decide such issue prior to the writ court exercising its jurisdiction.
Correct.
We have permitted Mr. Bhattacharya to argue on the point of law, and his argument is similar to that of the appellant, that of the respondent in the writ petition. In addition, he related to such and such to urge before that a requisition from the president of the governor should have been made through Article 229(2) by the Election Commission. In our privacy view, the decision does not help because in the sense that the said decision was rendered before the inappropriate incorporation of the amended provisions.
Correct.
Then, my lord, the honorable decision bench goes to distinguish 2003 and 10. My lord, my respectful submission with your lordship is this. Similarly, I cannot make a submission of your lordship that, see, even though the decision bench has passed an order, lordship will go against the report on that. But if the subtle points left open by the honorable decision bench, my lord, can be asked before your lordship. Number one, it is just the time of view. It is not final because paper books have been directed. I stand on the same footing. The learned friend in the intervener has been granted the leave to ask the points before your lordship. I have a petition, subject to correction of your lordship, and I can ask the points of your lordship. Whether your lordship will pass an order at this stage, your lordship will wait for the outcome is up to your lordship. But I can ask the points pursuant to the lordship, the honorable decision bench order. So if you can ask the points of your lordship, I will be making the submissions that the 2003 circular still 2023 circular, 2010 circular, and not because this honorable court decision bench is order, I cannot make the submission process. Also because that refers to this and that and all that. I will make a submission to the lordship that can exercise jurisdiction in the petition to beyond the points of merit. That is my prime officer, subject to what the respondent. See if a lordship calls upon, I can place on the merit.
So from my case, kindly takes up once my petition once. Our petition number 9513. 9519. 9519.
Sorry. And I'm sorry, only one more point. When I replied to the notice calling for the training, it is not referred to my writ petition, and the show cause is issued. Show cause is everything, flexible, sir. The show cause is mechanical because it's not referred to the reply adopted positions. So therefore, the show cause on premises does not stand on the eyes of law.
Now, kindly take some page 46.
9519.
9519.
Yes.
Kindly see 226.
Yes.
I was to take training.
Yes. Micro observer.
I have taken training.
Correct.
These orders still subsisting, not cancelled.
Okay.
Factually, it is completely different from others.
No order.
But this man that when the first matter was taken up, he was shoot. He was meaning to be discharged duty as micro observer. 40 minutes stop. 26. Subbed on 13th. But immediately on 16th, first opening of the court, I have an application petition. In which way you have announcement to petition on the same day. I filed this petition. Now let I did not any just the witness upon subsisting. I cannot do both together. Circular.
Kindly take forward.
So you cannot submit. Which, this is circular dated 24th October 2008. But after 2-3 page,
Where from you got?
let first, second, but
2003.
It has to be decided.
The sixth division starts 7-8, not clause 11 is the relevant.
2008.
2008.
Yes. Appointment of micro observer guidelines.
Yes, yes. It has to be.
Hmm.
It is absolutely clear.
Clause 11.
Clause 11.
Yes.
In a plea, it is absolutely clear that in one case, the micro observer will be as present officer. Officer.
So you have a full guarantee that again the election commission has not changed these guidelines
No, yes, yes.
till night, because I have a doubt.
No, I have not. Except that it takes up clause 15 of the circular.
Clause 15.
Yes.
Yes.
Listening,
Hmm.
those reports along with the scrutiny of register 17 will be taken into consideration for taking a decision on recall to action against the delinquent police officer staff. Therefore, I have the authority.
This report along with the scrutiny of the register 17A will be taken for so what
The micro observer will
correct.
based on that report that disciplinary action will be taken against the police officer.
Correct.
And this comes to 2023 circular.
Correct.
But it takes up now a kindly page. I'm sorry that this is page 16 of the well, it's not paginated, but running page 16 that officer.
Hmm.
I will say got it. Handbook of the presiding officer. Clause next page, clause 9.3. 9.31.
There is no clause of 9.3.
It starts with handbook.
9.31.
Yes.
9.31. Yes.
Now that this is my problem. Show the same courtesy and regard at the police station. The moment the presiding officer is met, we have to show courtesy to the micro observer. Now that currently takes up, I annex a bunch of documents to show that who have been appointed being the lesser in rank. Now that I have prepared a supplementary affidavit from my university, that is the Bishop University, 60 blood. My university, I have annexed a bunch who are lesser in rank. 16 is from my university, a clerical staff from the same district have been appointed as micro observer on 17th April. Now that is also important. On 17th April, he have been appointed as micro observer, and on 13th, I have been.
So that's why the very first day when you persons have moved the writ application, this court has said one thing. No. Living in the sea not to take the revenge from the crocodile. If you are living in the sea,
Yes.
then you not to take the crocodile so easy.
But I will say
Best example.
I understand that. But I will be placing the decision was mixed up.
With regard to division bench, not to make any observation. Only you say if that is not applicable, then I can. With regard to any comments on the division bench, this court will not.
Say that the other side misled the court.
something really bad. I'm sorry.
You have to comment on the did you record? This is the high.
This was not is from 16
Of the
of my supplementary correction. This is from Showing. Now can you see Shumit Agarwal is a multinational staff.
correct. Bolpur.
7th was appointed blood. And 30th blood,
So tomorrow is the election.
yes. No, no, I come wait. But still my
Hmm.
that you have been your appointment my professor has been cancelled. I'm like 24 from the supplementary that is staff. Staff that have been appointed by professor.
Where is that?
It's 24. So introduce Clark. And what I have, he will have disciplinary action over me. He realize I am a, but I have some respect that I have on. It's 22 minutes that Clark. It's 22 minutes can you see Clark. But all this bunch I have annexed. All are millet.
Page 20.
Page 22 millet. Is we were expecting that the election commission will place him. Page 22 millet. But this entire bunch is not either Group D or Clark. But I am an associate professor of a university. Now, I have shown guideline state that they have discipline control of me. And I have to show cards to the clerk.
Okay. That's all.
Now, kindly see.
Yes. Continue.
Now, kindly see. I'm sorry, just. Sir, Achin. Sir.
Yes, तू बोलो फैक्ट बोले जाओ
Just a second. Kindly see paragraph 23. 23 minute. That's 24.
Yes.
Unfortunately, the petitioner failed to take decision.
Did petition?
No, petition is order. I'm sorry. So the submission.
In brief, my lord, if I may permit to interrupt, division bench did not have these facts which now Mr. Shamim is placing before lordship, which would show, my lord, a clerk can have some sort of, my lord, control, maybe disciplinary control over the associate professor. The honorable division bench, my lord, did not have the benefit of these documents, and therefore was pleased to hold that yes, presiding officers can act independently and there is no controlling authority to others. That was the distinctive feature.
Okay.
But because of these new facts, my lord, I think your lordship would be kind enough to interfere.
Okay.
This is observation measurement. Paragraph 24. The petition also listed how each member under a person is different members. So this is a document. And now I have stated your lordship that there are from my university having lesser rank, I mean appointed by the observer.
Yes.
Solve that. I am not troubling your lordship.
No,
Paragraph 32. lordship, has heard the argument that the view of Article 29B, these petitions are not treated. Sir, I want to temper the argument because I think that this petition is treated under Article 26. And because the bar under 329B has to be read with the chance of the petitioner to file the petition under section of the complaining about definition. It's not that you have
No, not that. I have held with regard to non-maintainable with regard to having the alternative remedy under the act itself for the election petition. With regard to the administrative decision, this court has not held with regard to the writ petition is not maintainable. That this court has held writ petition is not maintainable because he has challenged the nomination paper. The nomination paper.
Okay, that's a different matter. That is election petition.
Correct.
No, but normally what happens is whatever comes up regarding an election, you come and say 226 not maintainable in view of 329B. I don't agree.
No. That this is court is also not
Yes,
on that.
the correct.
That is not on that.
Conceding.
This court is since beginning.
Yes.
I am accepting the writ petition.
Yes, I agree with
This court is accepting the
humbly
writ
agree.
petition. Only this court is rejecting the writ application only on the ground of the maintainability with regard to the candidature.
Correct.
Challenging of the candidature, that is the action.
And
Because administrative action, that is different.
I humbly, my lord, submit, my lord, that the election commission agrees, my lord, and submits to that view. But when you're coming one day before the election, then I want to, my lord, invoke paragraph 32, subparagraph 5 of this judgment.
Yes.
Now, this is where 226 is maintainable.
Yes.
The court must be very circumspect and act with caution while entertaining any election dispute, though not hit by the bar of Article 329B, but brought to it during the pendency of the election proceedings. The court must guard against any attempt at retarding, interrupting, protracting, or stalling of the election proceedings.
Correct.
So that is why I'm saying.
No, that's why
tomorrow, my lord, is
then
voting.
you have to give answer.
Yes.
Okay, one day before. If you are giving the order one day before, where the litigant will go, kindly come to the page 22 of the supplementary.
Sir, I don't have a.
Kindly come to the page 22 of the supplementary.
Yes.
There are 3 documents you consider to satisfy this court. If the persons have been given a presiding officer, the micro observer,
Yes.
then again you are giving the presiding officer and the clerk has been given the micro observer after that.
Yes.
Kindly satisfy this court. That's all.
Yes.
Nothing else.
Yes. Of course, I said. Now then, my lord,
So I am referring the 3 documents. And you consider that and give the answer. Kindly come to the page 46 of the writ petition.
the supplementary is, I think, only 27 pages.
No, the writ petition, first you come to the writ petition 46.
Yes.
46. Correct. This is the first order.
Yes.
13 March, sending it to training for the micro observer. Sending it, so you have invested you have on the public exchequer, you have given the training for this petitioner, micro observer. Now kindly come to the page 49. 39, presiding officer.
Yes.
49, presiding, once you have given the training of the micro observer, you have given the presiding officer, okay, the court will not, it is up to you to give. Now kindly come to the supplementary affidavit, page 16.
Yes, my lord.
Type of the duty micro observer, kindly see the designation.
Yes.
And now come to the judgment of the order passed by the Honorable Division Bench, which here referred paragraph 24.
Paragraph 24.
This paragraph 24, page 35. Kindly see this.
Yes.
And page 16 is the 17th April order.
Yes. No, I can't understand, Lord, the argument because the premise of the division bench judgment
is different. Let's not first see what is the role of a micro observer, what is the role of the presiding officer, and
No,
what
so
is
for-
the role of the
no, for-
presiding officer.
For that, if you are again, then you come to the,
So I
you have
argue
given,
it afresh, I have no problem.
no, you're given the notification because I am shortcutting the matter.
Yes.
I am
No, no,
shortcutting
it
the
has
matter.
to be because your lordship is not told something which is not correct, it can't be shortcut.
Correct. Now come to this document. Document page, there is no pagination, I don't think so.
So you please see the whole handbook.
Yes.
I'll show you the whole handbook.
No, come to the 24th October 2008, your notification, Election Commission.
24th October notification.
Yes, 2008 notification.
Page
24th of October.
Of this compilation.
Yes, not compilation, yes, compilation, 24th October
Immediate.
2008. Page 3, paragraph 11.
You
So,
It is not part of the writ petition.
No, that's why this bunch of the document. That is not part of the writ application.
This circular of the
The
election.
guidelines of observer.
Yes, observer.
So that's why your lordship will please see
Hmm.
what is the role, because I don't think, my lord, that the submission which is made, I humbly submit, is not, my lord, appraising your lordship of the entirety of the role
Yeah, that's
of
show
the
me.
micro observer, etc. Right?
You say that the micro observer is not about the not about the presiding officer. I will record your submission. He will not bind the micro observer's directions. I will record that. Nothing else. You say the micro observer not about the presiding officer. I will record your objects. I will record your submission and will dispose of the receipt application with a certain direction. That's all. Nothing else.
Any hierarchy.
No, sir. Kindly see. That's why. That's why the division bench.
Let me argue.
Yes, argue. You argue.
The result of my arguments, the division bench held that.
Correct. That's why. That's why
the same argument.
That's why
Then perhaps your lordship will also hold that.
That's why I'm
without
telling
me
you.
making the argument by learned.
That's why I have given this point. You satisfy this code. That's why I'm telling. If first you show the micro observer is not in the higher hierarchy than the presiding officer. You show me that.
I will.
Yes. So
No.
if it is not a hierarchy, then I will record that submission. Nothing else.
Of course, that can be done. No, this
Yes.
is not a question of a hierarchy. Because there is no.
Because your guidelines, if you're again the guidelines has come up the election commission 2000 year.
It's not a question of guidelines. Your lordship will have to appreciate. First, let us see what the presiding officer does. I'll take a little bit of time.
Yes.
Since your lordship, my lord, is saying this, I'll take a little bit of time. I don't have multiple copies with me today because I thought that after the division bench order, same question won't be revisited. My learned friend will, my lord, forgive me for not giving him a copy. Now, my lord, please see the handbook of the presiding officer.
Yes.
Please come to. Lord, please see what his role is. First, Lord, please see.
Page.
Lord, first is clause 1.4. And Lord, may I start with the observer's handbook first? This will make it more clear. This is what I had done yesterday.
Yes.
Lord, please come to clause 3. Overview of observer's duty. This is not grade 1, grade 2, grade 3. This is the wrong impression given to courts.
Yes. So
Please see what is the observer's duty.
yes.
By dint of their seniority and long experience in administrative service, general police observers are expected to be in a position to assist the commission in the conduct of free and fair polls. They will also be able to oversee the efficient and effective management of the electoral process at the field level. For all purposes, they will act as the eyes and ears of the commission during the period of the election and not the mouthpiece. and provide direct inputs to the commission from the field as an interface with the election machinery, the candidates, political parties and electors to ensure that the acts, rules, procedures, instructions and guidelines related to elections are strictly and impartially complied with. So, my lord, they are the eyes and ears of the commission.
Correct.
And general oversee.
Correct.
Now, my lord, please come to 8 at my lord page 5. Section 20B of the
Page-
Representation of People's Act has vested the observers with some statutory powers. They are empowered to direct the returning officer to stop counting or not to declare the reason specified in section 20. Besides the above mentioned statutory powers, they have got very important roles to play, which includes A. Observing process of scrutiny, etc. by RO, examination of video clipping, effective monitoring of implementation of MCC, and detecting cases of violation of the Model Code of Conduct, checking account of expenditure, dispatch of postal ballot, checking software, observing, regulating and counting process. Now, my lord, please come to their role, which my lord summarize. Quickly, my lord, see this. I don't want to take so much time. From A, illustrative list from A
Where
to
from?
my lord.
Where from you are reading?
So just after that, this is what they are supposed to do.
8. You are reading.
A to F.
A to
A to F, my lord, please see. Nomination, scrutiny, withdrawal, and symbol. No, this is not observed. It's really, my lord, they are the eyes and ears of the.
no. This is before the. What is the duty of the observation? The polling station should show me.
My lord, 5 minutes. I will show you a lot.
Correct. Show me. Show me.
I am showing.
Because it is with regard to the before. Show me at the time
This
and
is not changed.
in the polling station. Show me.
Polling station is under presiding officer.
Show me. That's why.
Presiding
Show me.
officer's handbook.
Show me. No, with regard to, so as per your submission, at the time of polling station, they are micro observer and no control over the no control over the presiding officers.
But that is not my submission. This is not a case where A is above B, B is above C. This is where they are acting together.
Then if Mr. Chaudhary, if you're saying that, if you're saying that, if your submission is accepted, then kindly come to the 3.
Come to 3.
Yes, clause 3, page 2.
Clause 3, page 2.
Clause 1.
Yes.
3.1. By the dint of the seniority, you are telling that there is by the dint of the seniority. Then it starts from the dint of the seniority and long experience.
Yes.
Can the professor, can the clerk will be senior than the professor?
Observers are usually appointed. My observers and micro observers are appointed from outside the state usually. When it is not possible, some other persons are also included.
Okay.
And professors, assistant professors are appointed as persons who are presiding, they are presiding officers. And then there are returning officers. If your lordship sees the interface of duties, there are some duties. For example, there is under the act itself. If your lordship sees, my lord, I cited this yesterday. There is a particular section. I think they have to scrutinize the form 17 or something. So the observer scrutinizes form 17. It's under the conduct of election rules, but essentially presiding officers do not take instructions from observers. Essentially.
Absolutely.
While there may be some interface. And all the high courts say, don't be so touchy.
What about disciplinary control?
All the high courts say, don't be so touchy. May I show your lordship of the judgments? Please see. The conduct of election rules 49S.
Yes.
Form 17C,
Yes.
deciding officer prepares this.
Yes.
And this is not scrutinized by the observer.
Yes.
But this is not superintendence. Your lordship will have to not appreciate that A is not above B. This is not my boss, to put it in colloquial terms. We work together as an interface. And generally speaking, if your lordship sees the handbooks, the returning officer on lot of cases takes instructions from the presiding officer. But presiding officers generally, my lord, are not subject to instructions from the ROs.
So kindly record this statement, and that will suffice.
Now, when you say that there is nothing to be noted, it's all over here.
That is show me
I
what.
am showing.
Yes, show me your. That's since beginning, Mr. Chaudhary. I am telling. Show me what are the duties of the observer. Show what you are submitting.
I have showed your lordship as per the handbook.
You are not shown. Kindly come to the page 36.
Page 36.
Yes. 29. Clause 29. I think you have not read the total book.
Yes.
36 কোথায় চলে গেছে?
Yes.
Did
29.
So special observers poll the activities. Observers oversee the actual poll. Observers available should tour the maximum number of booths. So this, my lord, in my humble submission, does not make him, my lord, superior to the presiding officer. They are acting as an interface.
Okay.
এইখানটা নেই নোটিফিকেশন আছে নোটিফিকেশন স্টার্ট টাইমটা দেখো
There is an interface. If he sees there's something going on in the booth, he can always tell the presiding officer this is going on.
মাইক্রো অবজার্ভার অ্যাপয়েন্টমেন্ট
Lord, please see 4.
Yes. 4 means.
Lord, what your lordship, Lord, showed me. 4 at page 37. Subparagraph 4, poll day activities. They should also go inside polling stations. I am making it more specific.
Yes.
And check for the progress of polling, compliance of the prescribed procedure by the polling officers in conducting the poll, the presence of polling agents, updating of entries in the presiding officer's diary, and such other matters that need verification. Register of voters form 70A must be checked with display of total votes polled on
So
EVM.
that's why.
So this doesn't make him not superior. This means acting on an interface, and that is what the division benches also.
If suppose you are the senior advocate.
Yes.
Correct. Government panel senior advocate.
Yes.
And administration has sent a peon to observe and give the notes what the senior advocate says making the submission to the court.
Yes.
Will not affect your what will say conscious.
No.
No, then I court is nothing to say, if Mr. Chaudhary, if you are of the view that the junior can observe then it can be reported to the seniority, you have no conscience on that, then this court is very sorry to accept the.
Your lordship is making observation. I have junior members, those who are junior to me. They will go and say that Mr. Chaudhary was unable to convince the court. Will it upset me? It will not.
That is different. That is with regard to the court. Court is different thing, but a peon is or the class 4 employee or clerk is coming to the court taking the observation of the submission made by the senior counsel of the administration and giving the
somebody else
and putting the question by the administration to you whether your conscience will allow to continue.
The administration.
Okay.
Please have a look at what the other high courts say and what this congress.
That is different thing. That's you show me.
You are told this is firstly, this is not a legal right, it's a national duty. Don't have these heartburn.
But national duty.
Do it for one day. Because it's administratively impossible.
Mr. Chaudhary, I also appreciate it is a national duty. Every person has a own right to give the service to the nation.
Yes,
that
to do it.
But the question is that the other authority is taking the service also to be clean.
Lord, please see.
You are giving one order in 2 months before and taking the advantage of that order. March order was passed, April filed, you got the order. Now you are changing within 2 days, you are changing the order and.
Shortage must be, otherwise why would you?
That's why this court, what is the unavoidable circumstances?
On 17, they have appointed a clerk.
So please, shortage, that's why. Please see the judgment. Milord,
Page,
Milord, please see paragraph 2.
Para-
Mr. Sajjan Sir, lecturer, DAV College, Jalandhar, who is a member of the Punjab and Chandigarh College Teachers Union for himself and on behalf of the said union as General Secretary, along with Dr. Sajjan Sir, has filed the writ petition under Article 2, praying that the order dated Sajjan Sir issued by the district election officer requiring the petitioner to be deployed for election duty in the district as presiding officers be quashed. Now, my lord, please come to paragraph 8.
yes,
In the returning officer's handbook, there are, my lord, observation under clause 3 that care should be taken to ensure that the presiding returning officer seniority is maintained. That's, my lord, paragraph 8. Now, please see paragraph 9.
you read the paragraph 8 also.
Sir, I will read everything.
Yes, read the paragraph. Why you are skipping the paragraph 8?
No, I'm only for time. Your lordship is
No,
always
no.
tell me.
With regard to the important, I have a time.
Sir, I
also have lots of time. The second contention is to the petitioners that if of such conditions can be declared.
You are reading.
Read.
Paragraph 8, yes.
I'm sorry.
8.
Encouragement, purchase license. Paragraph this one. The second contention, the petitioners that even if the employees of such colleges can be deployed for election duty because of Article 324(6) of the Constitution of India, read with Section 159 of the same Act, still the dignity to their status and assignment of responsibility was to be maintained. In this regard, sir, refer to the instructions issued by the Election Commission of India in its handbook for returning officer, Chapter 3, relating to polling personnel under 2.7. It is postulated that seniority of the official should be taken into account in every case and should be ensured that a senior officer is not duty under the official to him. The council also makes a reference to clause 3 of the same chapter. The presiding officer is required to be a gazetted officer as far as possible. But this is the handbook of the returning officer. Your lordship can take it from me that there are at least 70 provisions where your lordship will see him directly reporting to the presiding officer. So, Milord, this is therefore included for the purpose of ensuring that there is. Milord, please have a look at. I'll show your lordship.
আমি একটা কপি দেবে
আর নেই কালকে থেকে বিলিয়ে বেড়াচ্ছি
It just shows you, okay?
Milord, 2.5.12. There's a wait now. 2.5.12. If you don't have a copy, this is page 11.
Just as an example.
Two point five point one.
1.12. At the time of dispatch
Yes.
of the polling parties at the dispatch center, RO should brief the presiding officers concerned about vulnerable locations within the polling station area. There are no such provisions. So, Milord, the returning officer actually goes. Milord, also, Milord, please see page 9 once. G.
G.
Yes.
page
Page 9. Location of polling station and private building, etc. 3-4 lines down. Lordship has seen page 9.
কোন বছরের হ্যান্ডবুক
Yes. G.
কোন বছরে? 23.
দেখছি
Milord, G.
Yes.
then Miller building is under the control of presiding officer. Lordship has seen that.
Yeah.
And then security arrangement at polling station and within the above areas on the poll day will be the responsibility entirely of the state police under the control of the presiding officer. So this is Miller. Presiding officer is actually higher than the RO. Provisions, I can show you, Lordship, actually understood. Will not brief the presiding officer or show him things, which is why in the RO handbook it's mentioned that seniority should be maintained. We will also see 5.12 at page 11.
Yes.
At the time of dispatch of the polling parties at the dispatch center, RO should brief the presiding officers concerned. So, this is direct. At the polling station, there is the RO, there is the presiding officer. Presiding officer is in charge. RO must brief him.
RO is not deep, no problem.
So, this is the direct correction. The reason this is
Here question is not the RO.
Role of micro observers, it's not so interface. So there is no reason for the presiding officer to feel that he is subservient to the observer. Observer goes around saying something, he will go and tell the presiding officer. So,
Yes.
so this is which one?
Paragraph 9 of?
Since your lordship is at the returning officer handbook, you can see below is 33. It is made absolutely clear that in no case micro observer will act as presiding officer or polling officer. His task is to observe.
Where from your reading?
33.
Yeah.
The same handbook.
3.157. 3.15.7.
Yes, Milad. We see the third from the bottom. It is made absolutely clear. In no case, the micro observer will act as presiding officer or the polling officer. His task is to observe that the election processes are being carried out in a free and fair manner. There is no vitiation. It's really observation. The lordship will also see the observers. It's observation. So these are linked as an A superior to B. 3 points I make. Number 1.
Can the court put one question to you?
Yes.
Why the election commission so hesitant to complicate all the matters? You are having 2 years before declaration of the election. What are the total population of the area? How many the polling booths should be there? How many voters should be there? Why on last stage, 10 days, 15 days, 1 month, you are doing all these things?
I'll answer why this is happening. Micro observers.
It's not that the election commission has been appointed recently, that's why I could not get the time.
I wouldn't go, I wouldn't know, I wouldn't go into this is beyond when election commission is appointed.
Let me give the answer. Why only at the 19th? You are taking the benefit, the 19th hour, the petitions coming to the court, they cannot entitled to get the order. Why the election commissioner is taking the decision in the 19th hour?
The decision is not taken in the 19th hour.
17th, you are making the observer change. That's what I'm telling. So why you have not taken, you have no knowledge that the 5 crore persons in the West Bengal, they have to participate in the election process. How many polling booth, how many observers is to be recorded 2 years before you had.
So micro observers and observers are supposed to.
Whether the election commission want, the court has to fix the guidelines. For this, every time, every election, the court will be busy with all the miscellaneous applications.
Perhaps, Lord, I'm not sure, I'll check and indicate.
Perhaps, my lord.
You big books. Yes. All the things. So why you are not complying with these books prior to declaration of the
The answer is only after model code of conduct is imposed can all this be done, but I'll check.
No, sir. This is not correct. That will only applicable to district government and not to the election commission.
Look, as these appointments can be made, let me find when it is first possible, tell your lordship. If I just call up and find out and come. I'll just 2 minute time, lordship is annoyed.
I am telling. See, every day since the election starts, if you are going with the law, there will be no possibility for filing the writ application. You could have been maintained the seniority list. Here, these are the professors, they will be appointed. These are the clerk, they will be appointed. So there is how many micro? Suppose 1,000 micro observer. It has been taken the 2,000 micro observer.
So micro observers are constituencies. Professors.
That's why, Mr. Tacho.
Yeah, let's also understand. Professor says you can't self-show. So
You are that's why the law provides what to only unavoidable circumstances the person is to be bring for the election duties. So that's why what is your first duty? Your first
of the Constitution.
Okay. Continue. If you are telling that if the court cannot make any observation, that's why the court. Okay. Speed up. So
now I managed to
any other matter, any other point? Any other point in the matter?
Plenty, my lord. But first, Lord, don't be annoyed with me.
So not
dealing with me.
Yes. Continue.
Very well.
If you are telling that the court is putting the question to you, then it is very sorry to this. The bar is there whether the court has put any question. If you say that the court is putting the question to the counsel appearing, if it will amounts to the amount of the court with the advocates. I am not angry with you.
It's not a great matter.
Paragraph 9 of
which I was pleasing.
yes.
Provisions is to give back to the seniority. Start process. Expression seniority. Concept of commission itself sufficient so as to responsibility of such persons. The concept of seniority status of the class of service sufficient it is not asked to be officer to ensure as far as possible in the situation status has to be declared
those of circumstances and other as postulated who status. District, either district electoral officer and obviously is a president officer, but still serve as a lecturer or a professor. Situation the concept of guidelines. To some guidelines than mandatory. Such compliance will be put with regard to the purpose which that have been issued the process of election to be free and fair. Officers declared in documents etc. That's why process consider view much less any fundamental right.
Okay.
So this is number one.
Yes.
There are two further judgments below of the Madhya Pradesh High Court. Have a look. It's 147.
Yes.
It's paragraph 7. Process is deputed election duty officer who is informed of the rank status and pay scale to the officer deputed. This content discomfiture and humiliation. This kind of about the service locations of superior employees, officers. We serve as students. We recognize the right of civil from the posted conflict of the civil posted. So, see the paragraph. Court exercises power of judicial review to interference in the matter at this stage. The process of election shall come to a standstill, shall be postponed. Employees, officers to be deputed, shall be required to undergo training, etc. Professor, assistant professors, service, process of election cannot be categorized as rendering service against a civil post. It's actually much more sacrosanct only. That the foundation of democracy in our country, which are required to be conducted periodically, so that the people at large can have the representation and say in the process of governance at different levels. This process is not only important, but important for the existence and sustenance of democracy. Democracy has been recognized as the best form of governance. So, this is to ensure smooth conduction and conclusion of the process of election. Sacrosanct discharging his duties on the civil post and normal course. 51 process under the office of junior rank status and pay scale and discharge the election duty national service. Let me explain. Number one, the work of the book once. Because in case
No, first observer, it's over here. Please take the observer's handbook.
Yes.
Will you please come to, and I'm repeating, but please let me for your satisfaction for just 2 minutes. Please come to, page 2 once.
Yes.
Lord. See, also be able to oversee the efficient and effective management of the electoral process at the full level. The question, my lord, is let's make them supreme. Yes. That's what question number 1 I ask myself. That therefore, it makes them supreme. The observers will have to be the most putting in presiding officers. I have taken instructions. Observers and micro observers, every effort is made to appoint them from outside the state. Observers are officers. Effort is made. This is the effort which is made. Officers. Officers.
Then you come to the supplementary affidavit.
Yes.
Supplementary affidavit, page 16.
This one, no?
Page 16.
No. I think they gave it, no? Must be somewhere. No.
Like this one.
Oh, I found it. I found it. Yes, my lord.
You're telling that the retired IAS or the out.
Yes.
Now kindly come to the page 16.
May I just explain this? Explain this. May I just tell what is the scheme? Micro observers and observers are from outside the state. That is criteria which are trying to be followed.
So that's why I'm telling you.
Then the problem is sometimes you have to fill in because there is nobody else, which is when this is done. But then the lecturer would ask me that why are you putting in somebody who is a multitasking staff? And how will it not infringe the principle of similarity? Answer is presiding officer of where the professors are appointed. They are in charge of they are directly not apart from the scrutiny of 517 for every this person. There is no direct this is the lordship sees all the presiding officer. Observer is observe and remember. So that's to create a situation where the presiding officer is important to the observer. And
So under what circumstances the 2008 guidance was issued? Under what circumstances? Because it is issued, you are making the answer, submitting before this court on instruction.
yes,
Correct. Now
Yes.
kindly come to the 2008 instruction.
so let me solve the affidavit also. There is no time today.
That is
That is the problem.
So it comes to the 2008 guidelines. If you are telling so, your guidelines is something else. When the case has come before the court, you have instruction something else.
2008 guidelines.
Yes, kindly come to see. Clause 11.
This is
Clause 11.
In the middle.
station. So he should assess the preparedness during the he should regularly reprinted. It is been absolutely clear that this micro observer will act as presiding officer. I have also shown this to your lordship. So taking petitions from him.
That's why he was appointed the presiding officer. How you have changed to the micro observer?
Appointed as micro observer. So micro observer then.
Micro observer, then your presiding officer.
Okay.
Okay. Then
The point is that the presiding officer does not take instructions, so there is no.
okay. Next.
Next is clause 3.
Clause 3 of
petition is to be followed. Process of the
That's why, Mr. Chaudhary, if this court is having two contrary documents, the court you have to satisfy.
I'm trying.
You are relying upon this. Show me that 2008 notification has been superseded and 2000 have only following these guidelines. Then I will record your submission and will pass appropriate order. That has been the same thing has been done on the earlier occasion. Twice or thrice this court has put the same question. When the court has passed an order, then you put all the document before the division bench. But when this court is putting the question, you persons are not able to produce the document, then the court has nothing to do but to pass an order.
Affidavit is given in court.
Whatever it may be, your authority should be clean, and what your authority don't know what the guidelines with you are having.
To produce those
documents. 2008 your documents.
So this is the I'll just tell you, Lordship. I started with saying that micro observers are attempted to be brought in from outside the state. Where not possible, we have to somebody say he's not come. So from the state. Number 2.
So that's then again the question. What where is the circumstances you mentioned for issuing this order?
Number 2, my lord. When it comes to professors,
saying all the things, it's very easy before the court, but you have to prepare the document is something else. So your guidelines itself provides that if any unavoidable circumstances, the court is not standing on the way, but you have to put all the things on what is the unavoidable, what you okay. Okay.
May I just briefly reply?
Assistant professors, their primary work is teaching. So they can't observe us to at least meet the marks work is there, in the constituencies. You can't expect professors and assistant professors to do that.
Yeah, you have done this. Can you see the first? You can you see the 46? Again, you are contrary. Your submission is contrary to the document. Can you come to the page 46?
46 of
this, again, the professor has been given a micro
exception.
Okay.
So exception.
Then it will okay. If you have taken 3 months before the training, I am only in this matter. Kindly see the 19th March. 19th March, this order is passed. You are telling that one person has been taken. No problem. You can take it.
Yes.
Now kindly come to the what is the circumstance, and now 11th April. You change. Which difficulty with the petition, with the election commission? Next.
So teachers are just by one. This is the now the next the legal question is that obligation
Obligation is under the Constitution. Under the Constitution, the Election Commission does not have staff. And in a request to the President, staff is given from the center and state government.
Correct.
So this is, and it's akin to, this is number one.
Yeah.
It's a constitutional duty of every central and state government staff to render service. This is not service jurisprudence. Only
No.
placed on. Now look at the division judgment.
Yes.
After this, it is my learning from sections. Please take the division of judgment.
Yes.
The supplementary. This is a principle constructive judicata is not permitted to issue exposed as far as the situation is concerned.
Oh, Sabi was not speaking of me.
So, if you have
Okay. Leave the personal comments. Kindly come to the. Leave aside the personal comments.
Okay.
Okay.
Petitioner. There was one petitioner application.
Okay. Show me. Show me. Which?
Petition, etc. were considered.
Yes.
You are reacting. This is
Yes.
the finding of the court. Six. This is presiding officers.
Yes.
Then paragraph 14. Presiding officer is officer. So much so that presiding officer is authority to officer if the polling officer appointed by the district election officer is absent. This presiding officer presides over the polling station on the date of the poll. Section 27 deals with the general duty of the presiding officer to keep order in the polling station and to see that the poll is taken fairly. So the observers before the election commission, observers who are officers of the government. The contention of the reputation and in the plenary is that they should be appointed as observers, micro observers, etc. Such contention is not the observer has to be an officer of the government. Election the reputation was quoted from paragraph 18. The observer duties under clause 3 of the handbook, etc. They have to act as representatives of the commission. 5 lines from the bottom, 7 lines. We do not find that the observers are playing a superior role to the presiding officers.
Okay.
The train is not permitted to make an argument, and we are interim stage at this stage, we are not contrary to this duty.
Okay.
Rather, there will be between the commission and the election machinery involving candidates, political parties, etc. So also interface with the which is quoted below does not indicate that Serving officers. Serving officers are located in any operation are given to each category.
Yes. Yes.
Serving officer are being outlined in
Page, paragraph? Yes. Yes. Yes.
Station. Some class sector officers points that sector officers act as an interface between the presiding officer and the recording officer. The presiding officer may take extra position of sector officer. So sector officer should be and then
Yes.
then informs that the petitions being appointed as sector officer. It's does not members of society. Certain group of officers were placed under sector officers or assistant sector officers. Discuss the role of the sector officers and the deciding officer has been placed below. Sector officer, assistant sector officer, presiding officer, not required to report to them.
Okay.
Is all the sector officer it required to report from sector officers. Sector officers are only in office. The observer is not comprehensive and elections, whether the patients are required to discharge serious obligations for education are in charge of the station for some conditions appear to be independent. Sure. Respect Mr. Teacher and every citizen. For national interest, they saw the duty out of his personal advice. 2023 placed class 6 placed.
Yes. Yes.
Instructions. So to please staff, etc. Starting officer, it's not certainly either observer or sector officer. But this is the finding at page 41.
Yes.
And spreads over 4 months at various levels. Whenever the college teachers have to discharge their duty and prepare the officers police station
to ensure smooth and fair elections.
Yes. Next. That's all. All from the bar.
So I can say that this is wrong.
Why, Mr. Chaudhary, all these things you're submitting, division bench is wrong and all. Why you are submitting all these things? You're submitting the comments. Why you are bothering on the comment? Then
I won't, I know not to bother.
yes. But why you are making?
I'm sorry, Lord, I shouldn't have said that. I apologize. Like paragraph 40.
Yes.
Yeah, right, Lord, I shouldn't get carried away. Yes.
If your ear will be in the other side,
Yes.
you block your balance in
And this is when I say litigation is like a game. You can't fight, you lose. It doesn't create any difference.
different.
It's not different. So I always believe in being polite. In fact, I may take 1 minute. Years ago, as a junior, blood is hotter than Mr. Bhattacharya was on the other side. I always say this to all the juniors. You remember, you would forget me now. I said something which should not have said. Quote 13. All that I said was that perhaps my learned friend is too junior to make this audacious statement. That's all. Shut up immediately. That's what we learn from.
Yes.
Similar. The scheduled date of election, the order was passed. The effect of the order will result in a chaotic situation. Election Commission will be in position to requisition fresh persons to act as presiding officers and impart training. His lordship did not conclude what exactly would be the role of college teacher, which would be commensurate with the rank. We stay the operation, consequences will follow. And the books. There are two judgments. The Madhya Pradesh High Court. Remember those other two? If I don't have them, I won't cite them. It's not here. Which also says that you have arguments. This is, it's an understand. You are sitting. One day. And on the other hand, if I could make you an observer for one to this court, saying that don't have time to students will suffer.
No, that
It's a situation.
no, this court is not on. This court is of the view. Then once you are having the time in your hand,
Yes.
2 years. So why in the last stage all these things? Why you're not keeping the reserve? If you find that from not coming, why not keeping the 10% in reserve?
Your lordship's observation is perfectly correct that if one is more organized, then it is, these situations are avoidable.
Yes. Person knows I have been given the training of the micro observer or observer, whatever. I have to do the work. If you're not coming, the authority will take appropriate steps. So you require 400 observer, you do the training to the head and 600.
It is not, this is.
So having the experience when the election is started, nobody will available in the government office.
Yes.
You are busy in the election duty.
Yes. Yes. You see, the situation is also the same now. So next, the issue is this, Miller. Tomorrow is the election. Now, Miller, because this has far-reaching consequences. But this is in such large numbers.
Never be for giving benefit to the one party gain one. Court has to be neutral, but
Yes.
has to see the authorities' action.
So I understand what I appreciate what the lordship, what comes from your lordship says. You can come cite urgency, not short over something. What to cite urgency, careful from day one. I totally appreciate that. The election commissioner is not I apologize.
And it is not your case the first time. You are citing the such judgment on all state the same thing is happening.
Situation
Today for the last several years.
sheer numbers. And so after elections are
Thank you.
leave to your affiliates.
Even that in the meantime, from their own documents,
Not Mr. Samim, after the division bench order, what remains? Besides present.
division is passed order accordingly.
Correct.
That is not that I'm placing that.
Yes.
Because
70, 73.
he wants to file affidavit since the documents are not with.
It's all the matter be tagged within the appeal.
Yes, yes.
What to do? I researched. He researched. Researched.
Hmm.
And this was
So that's why once adversary order is passed, then only the authority will starting the research. When till that the authority was sleeping.
very interesting. First time I did an election matter, very interesting.
Yes.
But
Yeah.
9.21 at the bottom.
73, 9.31, observer,
Is from the hand officer.
presiding office.
I've shown this from the circular.
73,
Now I'm showing it from the document.
yes.
17.31.
9.31, yes,
Last line.
yes.
From courtesy.
So you courtesy.
Should courtesy. The observer appointed by the commission and furnish all information required by him. Now, the same courtesy and regard to the matter of at the hearing station.
Correct.
So this is the presiding officer who has to show courtesy to the micro observer. Not the hierarchy. This is not hierarchy.
But now this court's hands are tied. Kindly come to the paragraph 30 of the yesterday's order.
But it was not shown. This clause was not shown.
Not shown, but
See, this is nothing. This is not direction. What about throwing up the police station? You can throw up micro observer. It's got
Difference. Each time when the matter was taken up, the time passer, it is different. It has observed me that the case.
the point of law.
Now, in case, I have with me two orders, which I was appointed micro observer and which I was appointed as plea officer. Now, that I have shown from the circular that the micro observer discharged duty to the plea officer from the circular. Now, that today I have been appointed with the two orders. Now, that so from a plea officer, I am ready to take I'm still this happening. I'm to discharge duty. To take there and take training. Now, let so far management is concerned. Yes, I've shown the discipline also control. So I just reading once again. The scrutiny of the minister for taking the decision and
where from your duty?
that I have shown to you
Guidelines.
from the guidelines.
The guidelines.
Yes, I showed you lordship 17. Showed the division bench also
Just a
yesterday.
second. This is from 2008 guideline
Yes.
of the micro observer,
Clause 15.
clause 15. This was not never placed.
Please.
What are you saying? Please.
Okay, yes. Then- Okay, I have taken notice.
Now, at last, they are taking the plea that after this court and while seeing their own documents, This is blood management.
Manual of the management.
Second paragraph from the
Yes.
it starts with aspiration the election commission of
Yes. Yes.
the district can at least 6 months before. Now, can you see on the next page the schedule? You see schedule bar karo. But in the schedule, you see they have to let's check for group A, group B, group C officers have also got it. 6 months for, and
What the court is telling since morning. The same thing is.
now can you see the next page? This 4.3 arsenal requirement and availability. Arsenal requirement and availability. 4.3.
But Mr. Ahmed, please,
4.3 minute. Satisfaction.
please.
Chalo. This arsenal requirement and availability. That prior to election.
How will the deficit be taken care of?
How will
Take care of the
take care of the deficit? There, but taking care of all these things.
6 months.
On the month of March, that point me as micro observer. Now let on 17th April they are appointing let another. But if they don't require micro observer, they say that I don't require micro observer. On which I was appointed as an officer. Then done what? On 17th, you appoint as micro observer. March. On the 17th, after my appointment, they're appointing a clerk. We as micro observer. But these actions are arbitrary. Only one line from the judgment. I didn't cite to avoid that.
What judgment?
But this is of 79.
29 What is the next paragraph? 79.
1979, CSC 489. No, I will read one line.
Oh, Adi Shakti, tender matter.
First, the commission of the things are there. It is well settled. Mr. Law. Executive authority must be rigorously held to stand on which it processes its action. Charge it must scrupulously observe those standards. Action of an act in writing of them. It is all in that.
So that's why Mr. Chaudhary is telling that he admits it. Yes, with regard to the administrative action, all the seniority and all the things is to maintain. But here, with regard to the election duty for one day.
Oh, one day do it.
I don't know. Today it's impossible for me to take training. Well, I'll be doing something wrong on paper and keep suffering. The citizen of this state.
Okay. Yes.
This is paragraph 35 of the petition. I was the intervener.
But your lordship has seen that the honorable division bench has left
Which
open.
application you have?
My lord, item number 4, that is 9473 of 2026.
So what is your prayer?
My lord, prayer is same. I am slightly different.
Huh?
I am slightly in a different.
What is your prayer?
My lord, may I just a minute. My lord, I have seeken a declaration to the extent that the action of the election commission is, my lord, wholly without jurisdiction. That is my lord. My lord will kindly take this.
You have been appointed as?
Presiding officer, my lord.
Sorry. Yes, take.
My lord, just a judgment. My lord, kindly take this.
No.
My lord, kindly take this.
Petitioners have filed the petitioner in WPA number 9388 of 2026. Prayed for a direction.
One indulgence.
Prayed for a direction upon them, prayed for one indictment for a direction, prayed for an order for recalling of the order dated 19th March 2026
Let me
and reassigning
ask
the.
him, may I ask for leave? I'm sorry, Milord, if I. I'm sorry if.
Yes, yes, no problem. And reassign their election duties in accordance with the order dated 16 February 2010, as well as in terms of the memorandum dated 10th May 2018. Full list. The petitioner 9388 who is appearing? 9388 who is the petitioner?
9388, my lord, perhaps.
1988, I am for the petition.
What is your same submission with the Ahmed? Full list. In WPA number 9519 of 2026, the grievance of the petitioner. Grievance of the petitioner. For cancellation of the order dated 11th April 2026, and to restore the and to allow the petitioner to work as the presiding officer as per the order dated 19th of March 2006. 19th of March 2006. In WPA number 9473 of 2020. 9473 is your?
Yes, my lord.
What is your prayer?
My lord, I have been praying, my lord, similar prayers, only one additional prayer to the extent that jurisdiction point. All other prayers are similar, my lord.
Also prayed for.
Prayer B is the declaration, my lord. C is withdrawal, cancel or set aside.
In WPA number 9473 of 2026, the petitioner has prayed for recalling of the order, recalling of the setting aside the order dated 23rd of March 2026. The counsel for the petitioner in WPA number 9519 of 2026 submit that the petitioner was appointed as training as Mike counsel for the petition in WPA number so submit that on 19th of March 2026 the district election officer has issued an order for training of the petitioner as micro observer. And accordingly the petitioner has participated in the said training. But all of a sudden on 11th of April 2026 the returning officer has issued an order. Returning officer has issued an order by appointing the petitioner as a presiding officer. The petitioner has filed the supplementary affidavit. Wherein he has disclosed several orders and submit that the district election officer Birbhum has appointed several micro observers who are working either multitask staff, account assistants, junior officer junior management, junior associates, clerk and other designation who are the much junior, who are holding the much junior post than the petitioner. He submits the bill. He relied upon the notification, the circular. He relied upon the circular dated dated 24th of October 2008 and submit that as per clause 15 of the said circular, the observer will go through the reports, and if any further clarification is required, then he should arrange for the micro observer to be called for ascertaining those further details, full stop. These reports, along with the scrutiny of the Register 17 dash capital A, will be taken into consideration for taking a decision on repoll or disciplinary action against the delinquent polling staff. He further relied upon clause 11 of the said guidelines and submit that it is in the said clause, it has been clarified that in no case the micro observer will act as presiding officer or polling officer. Full stop. His task to be observed the election process is being carried out in free and fair manner, and there is no violation of any kind. By referring the said guidelines, he submitted that the petitioner was appointed as a micro observer, and petitioner has undergone training since the month of March 2026. Now, at the 19th hour, the respondent authorities have changed the designation of the petitioner and appointed as presiding officer. And in place of the petitioner, the junior staffs who are the clerical staffs and multitask staffs have been appointed as a micro observer. Full stop. He further submits that the respondent authorities have issued the order and initially issued an order on 19th of March 2026, wherein the petitioner has been directed to undergo micro observer training, and following the said order, the petitioner has undergone the training. But on 11/4/2026, the respondent authorities have changed the designation of the petitioner as presiding officer instead of the micro observer. And subsequently, when the petitioner further came to know on 17th April 2026, the juniors have been appointed as juniors, and the post is much lower than the petitioners have been appointed as a micro observer. On 17th of April 2026, the petitioner has filed the present writ application immediately. And thus the authorities cannot say the petitioner has filed the present writ application at the last stage when the election is to be held tomorrow. Full stop. Learned counsel appearing for the election commission. The learned counsel for the petitioner has further relied upon the manual of the district election management planning 2023, wherein it is mentioned that as per the election planner of the Election Commission of India, the DEPM to be prepared at least 6 months before the tentative poll date, and the action plan and the manpower plan has been specified in the clause 4.1 onwards. And in 4.3, the personal requirement and availability as well as the personal required each category is to be taken into consideration before 6 months of the election. But in the present case, the authorities have issued the order in the month of March, in the mid of March 2026 for appointing the petitioner as a micro observer. But now all of a sudden, within 10 days before the election, have changed the category of the petitioner as presiding officer, and in place of the petitioner, the junior persons have been appointed as a micro observer. Full stop. Learned counsel appearing for the petition for the Election Commission of India has relied upon the handbook of the returning officer, wherein clause 2.2 within bracket small g, it is mentioned that it is mentioned that the security arrangement at the polling station and within the above area on the poll day will be responsibility entirely of the state police under the control of the presiding officer. Further, after the nomination are filled, it should be ensured that the owner of presiding officer. He submits that the presiding officer is the overall in charge of the polling booth, and as such, it cannot be said that the macro observer is in the high hierarchy than the presiding officer. He further relied upon clause 2.5.12 and submits that at the time of dispatch of the polling parties at the dispatch center, the returning officer should brief the presiding officer about the vulnerable location within the polling station area. In the electoral roll, the sections within the part should be marked for proper monitoring. The presiding officer shall submit a report indicating abnormally low percentage of voter turnout, if any, within the sections, particularly within the reference of the vulnerable location. He further relied upon clause 3.15.7 and submits that in the said provision, the role and functions of the micro observer has been clarified, and it is made absolutely clear that in case of micro observer act as a presiding officer or the polling officer, and in no case the micro observer will act as a presiding officer or polling officer. Full stop. Mr. Jishnu Chaudhary, an advocate appearing for the Election Commission of India, further relied upon clause 3, within bracket 1, within bracket 2, and within bracket 3 of the Observer Handbook Volume 1, as well as clause 29 within bracket 1, within bracket 2, and within bracket 3 of the said handbook, and submit that in the said handbook the duties of the micro observers have been clarified, and it cannot be said that the micro observers are the high hierarchy than the presiding officer. Full stop. Learned Counsel for the state for the Election Commission of India has further submitted that the Honorable Division Bench of India in the case of Election Commission of India versus Rupa Banerjee Nee Samajpati, passed in MAT number 719 of 2026, dated 21st of April 2026, the Honorable Division Bench has taken note of section 26 Honorable Division Bench has categorically held that the observer are playing a superior, and the court do not find that the observers are playing a superior role over the presiding officer. Rather, they are the interface between the commission and the election machinery, involving candidates, politically parties, electors, etc. The Honorable Court further observed that the observer is an interface with the RO and GEO and ARO, and the role of observers, which is quoted below, does not indicate that they are any controlling function over the presiding officer, or that the presiding officer are inferior to the observers in any way. The fields of the operation are different for each category. Full stop. The Honorable Court has also taken into consideration of Section 20 capital B of the Representative of the People's Act 1951. Full stop. The Honorable Division Bench. Full stop. He further submit that all the points have already been taken into consideration by the Honorable Division Bench, and has stayed the order passed by this court, wherein this court was held that the assistant professor or associate professor cannot be assigned the duty of the presiding officer. Full stop. Once he submit that, once the division bench has already held has already considered and the matter is pending before the honorable division bench for further consideration after completion of the after exchange of the affidavit. Thus, it would not be proper for this court to interfere with the to pass any order in the present writ application as the point involved in the present writ application is also covered in the order passed by the honorable division bench dated 21st of April 2026. Had the learned counsel no, the counsel for the ECI has relied upon the judgment in the case of Dr. Dilip Kumar and others versus State of MP, reported in 2015 SCC Online MP 1947, and submit that in the said case also the honorable and the High Court at Madhya Pradesh has held that the petitioner how to raise above parochial thinking of heart burning arising out of their posting in the election process under an officer of junior rank, status and pay scale, and discharge their election duty by treating it to be national service. He further relied upon the judgment in the case of Punjab and Chandigarh College Teachers Association Union and others versus Election Commission of India, reported in 2004 SCC Online P&H 450, and submits that in the said case also the honorable the division bench of the Punjab and Haryana High Court has held that even if the officers employed in the different undertaking or the department have to work for a day in a coordination or even under a person who may otherwise be a junior to them in terms of pay, etc., and are assigned a definite job in the electoral process, then we are of the considered view that it would not infringe any known principle of service jurisprudence, much less any fundamental right. Full stop. Learned counsel for the Election Commission of India has further relied upon the judgment in the case of Election Commission of India versus Ashok Kumar and others, reported in 2000 volume 8 SCC 216, and submits that the court must be very circumspect and act with the caution while entertaining any election dispute, though not hit by the bar of Article 329 within bracket small b, but brought to it during the pendency of the election proceeding. The court must guard against any attempt of retrading, interrupting the protracting the stalling of the election proceedings. Full stop. Had the learned counsel for the respective parties peruse the materials on record. This court find that the main grievances of the petitioners is that the petitioners are working as assistant professor or professors in the different college. Initially, initially in one of the case, the petitioners have been appointed as a micro observer. Now they have changed the post and change in the duty of the petitioner from the micro observer to the presiding officer, and in the place and the authorities have appointed several junior officials as micro observers. Full stop. This court has perused the order This court has perused the recent order passed by the honorable division bench of the High Court of this court, dated 21st of April 2026, wherein the division bench of the High Court has dealt with all the provisions and the handbook of the returning officer, observers, and the presiding officer, wherein the Honorable Division Bench has come to the have prima facie come to the prima facie recorded that the court did not find that the observers are playing a superior role over the presiding officer. Rather, they are the interface between the commission and the election machineries, involving candidates, political parties, electors, etc. The observer is also an interface with the RO and DO and AROs. The role of observer, which is quoted below, does not indicate that they have any controlling functions over the presiding officer, or the presiding officers are the inferior to the observers in any way. Full stop. The Honorable Division Bench has further held that paragraph 20, further 2021. Full stop. The learned counsel for the petitioner has drawn the attention of this court to the paragraph 24 of the Honorable Division Bench of Order, wherein the Honorable Division Bench has held wherein it is held that the writ petition did not demonstrate how each of the members who was appointed, had been placed under the personal less qualified or the lower in the rank of having lesser income than the said member. Full stop. The petitioner, by referring the said paragraph, has drawn the attention of this court to the order dated 19th March 2026, wherein the petitioner was appointed as a micro observer. Subsequently, he was appointed as given the work of the presiding officer, and in place, and subsequently on 17th April, the authorities have appointed the clerical staffs as the micro observer. This case also consider the submission of the petition and the observation made by the Honorable Division Bench in paragraph 24. But in paragraph 23, in paragraph 18 of the judgment, the Honorable Division Bench has already clarified that the role of the observers, which is quoted below, does not indicate that they are having a controlling function over the presiding officer, or the presiding officer are the inferior to the observers in any way. Considering the above, this court find that the Honorable Division Bench has already dealt with the matter and passed an interim order. Pass an order directing the college teachers wherein the interim order passed by this court has been vacated, and the professor and assistant professors have been directed to perform their duty as the presiding officer. Considering the above, this court also did not find any prima facie case in the present application to pass an interim order. Thus, the interim order is refused. Full stop. The respondents are directed to file affidavit in opposition within 4 weeks. Reply, if any, there to be filed within 2 weeks thereafter. List the matter as adjourned motion in the month of July 2026. July, let you complete first.
One more thing. Any steps taken on the result?
What steps? Already you have to, what steps? So you have kept for at this stage, no interim order. Let the court pass, let the court.
Only one of us have been served with a show cause. I have taken that. Now one of us has been served with a show. I understand the difficulties of this court since the observation. But when this is difficulties. And
if anything, the challenge, you are free to that. Go and
what? Any steps will avoid by the result. Because
Go and join, go and
No,
join.
I'll join.
Yes.
I'll join. In the meantime, since there is show cause notice, that's why my any steps taken on the
During the election,
today, there is no scope for training yet. So I will join. I have two orders, micro observer and presiding of both existing.
Lord.
They were decided to, I will do that. Can you clarify that? And we had, in the meantime, any steps taken on the basis of the
as this court has refused to grant an interim order, accordingly petitioner directed to comply with the direction passed by the author.
directions what will it?
They will give the directions what was to
Lordship, I'm by Mr. Jushnu Chaudhary in the matter. Lordship, we submit that no course of steps will be taken against them in regards the show cause notice.
क्या बोला ऊपर क्या बोला अभी last? This court did not find any prima facie case and refused to grant interim order. Accordingly, petitioners are directed to report their duty as per the direction passed by the authority. The learned counsel appearing for the ECI submits before this court on instruction that though the so-called notice has been issued against the petitioners, but they will not take any action against the so-called notice against the petitioner. Satisfied?
Great for your Lordship.
Oh, I did not require any rest. भेजा नहीं भेजा
চলো ভাই এবার ছাড়ো অনেক টাইম নিয়েছো তোমরা অন্য মামলাগুলো করতে দাও
Yes, who is for the petitioner?
মালাটা victor.
Item number?
Item number 7, Mala. This is violation of Milas order.
Where is the order?
My lord, that appears at page 20.
20?
20, my lord.
Yes.
My lord had been pleased to pass an order on 4th December 2025 directing the authority to take a decision. My lord, accordingly, the order was
Okay, issue notice, issue notice. The petitioner has filed the present contempt application on the allegation that the respondent authorities have willfully and deliberately violated the order passed by this court dated 4th of December 2025. The petitioner is directed to issue notice and to file the affidavit of service on returnable date. Let the matter appear on 12th May under the heading application, contempt application. Next. Call.
9 Millard. Yeah,
9 a to appear for the petitioner.
I'm responded.
Included documents on 9th March when my learned friend was given leave to file 4-5 documents by way of supplementary affidavit.
Yes.
But the supplementary affidavit is 130 pages. I'm yet to file an exception.
Nothing. No, nothing.
Also filed sales assessment report which does not have any signatures of my client. I've sought instructions on that.
May I submit one thing, Millard?
Yes.
Only very short submission. In terms of the peer, Millard, the authority has been decided to allow the run of the trolley and stall. So, Millard, your lordship kindly see. Pair 50, page.
So you have withdrawn that letter, impugn letter.
That they still not know. They have not withdrawn. And there's one particular document which
We are going to
You are allowing with the in terms of the interim order. So if you are telling that you're withdrawing that letter and you will allow the petition, you will take appropriate steps in accordance with law, then you can.
Yes. Only one word, Millard. Subject to the all payment of the all dues.
that has to as assessment. I have always been paying.
Then
But assessment, yeah.
You have mentioned in the written instruction. No,
it is that.
You take written instruction.
We have
Then tomorrow other advocate will come and say that they
No, we shall file. But we have if your lordship desire, then we shall file affidavit by letter.
No, I am
Intimating
because
the-
you are telling that in terms of the interim order, you are already allowing the petitioner to run the business, the trolley and the
Yes,
stall. Trolley and stall. Correct.
Tables. Trolley and table. Not tables.
Table. Trolley and table. Correct. Now you are telling that already, but that is with regard to the interim order. If you are telling that yes, you withdraw that interim, that impugn order with the challenge. So I will pass an order. They were already allowing that, but the petitioner is
only one rider is required, but subject to the payment of the all dues.
Yes, subject to, if the
and-
respondent
yes,
will
yes,
make the
yes.
claim against the petitioner, petitioner should make appropriate, make the payment.
Always.
But you have taken the return instruction. Come with the return instruction. Or you do one thing. You do one thing.
No, no, আমরা বলে দিচ্ছি তো, your lordship can record my submission.
Lordship's interim order was completed after 2.5 months. I was out of business for almost 3 months.
Going to allow my learned friend, why, what is the question of?
In fact, the 3-month benefit I'm entitled to any event.
Yes, আর কি থাকবে, আর থাকবে না।
Where is the impugned order?
বলেছি তো আমরা, fair portion এ বলা আছে, fair portion এ বলা আছে।
Page 91.
Yes, yes. Yes, sir.
Where is the 22nd May 2024 order? Page 67.
1, 2, 3, 4, 4, 1, 2, 3. Third paragraph.
Page 67.
Page 68.
67 read with 91.
91.
89 onwards. 88 onwards. Yes, kindly come to page 67. First is this is the main order, impugned order. You are requested to follow the revised contractual period of trolley, table so and so so and so. You say that you are withdrawing this letter.
Wherever I'm entitled to 27, I don't have a problem. I'll pay license fees as per agreement. There is no dispute on that. I will never.
But if we allow the office to run the business of saving stalls,
No, that's correct. Then I will record that you are allowing the run the stall with the trolley, and you only to if the and only the
subject to the payment of all
dues. But what dues? Because the dues which you have kindly come to the 67, that is a disputed.
Yes.
Page 67 is the disputed dues.
1511 to the
Kindly come page 67, that is the dues.
dues. Then calculated it from also not till today period, all dues.
You do one thing. You have given the calculation in the affidavit.
Yes, yes.
You have given the calculation. Where is the last calculation?
Page 45 to work with. Page 45.
Page 45.
কত অবধি হয়েছে এটা?
Where is the total calculation? Total is 6,61,000.
No. Total.
Page
What page?
page 9, page 9, para 12.
Page 9, para 12.
Affidavit. Supplementary.
Affidavit.
Supplementary.
11 lakh. 11 lakh. 3 numbers of stalls.
Yes.
And 6 numbers of trolley and 1 number of table.
Yes.
So you do one thing. You take instruction. If you are ready to pay this amount, I will record and
Yes.
you pay. Bring the demand up here in now. I will dispose
Yes.
of the return.
Lordship keeps it after only 1 week.
Correct.
Keeps it after only 1 week, Monday or Tuesday, whichever day.
The respondents have filed supplementary affidavit, wherein it is allegation that the petitioner has not paid the license fee total amounting to rupees 11,78,707 with respect of 3 numbers stalls, 6 numbers trolleys and 1 number table at KGP and BLS railway station as license fees and penalty till 2nd October 2025. 2nd October 2025. Full stop. Learned counsel for the railway submits that as the railway authorities have allowed the petitioner to run the business with the stall and trolley, and thus if the petitioner will pay the license fee as claimed by the petitioner, nothing remains in the present application.
Paragraph 9 will not your
Lots of trolley and table.
trolley and tables.
Huh?
Trolley and table, that's
Correct, trolley and table.
Yes.
2 numbers stop and 6 numbers of trolley and 1 number table.
Yes, Lordship.
That is the mention you paragraph 12.
Yes.
Lordship.
Full stop. Counsel for the petitioner prays for time to take instruction with regard to the payment of 11,78,707 as appearing in paragraph 12 of the supplementary affidavit. Full stop. In view of the above, the case is adjourned. Let the matter appear. Let the matter appear on 4th May 2026.
Of results, kindly make it after go through the election results. Kindly make it
8 or because the 4th.
7th May. 7th May. 7th May under the same heading. And if the petitioner is ready to make this claim made by the respondents, come with the payment on the said date.
Still wanted to continue to.
Interim order is extended till the next date of hearing.
I'm getting.
ऊपर लिख दो supplementary affidavit filed by the petitioner respondent. Next.
Oblige.
My lord, I appear for the alleged contempt 1 and 2.
Don't the CPM. Why don't the CPM एक sir? Item number
11, ma'am.
एक CPM है.
CPN 168. But the order has already been complied with.
Huh?
Order has been complied with.
Where is the order?
But the
Page. Where is the order?
1 and
1111. Madrasa Service Commission, the writ petition dispose directing the to take steps in terms of the order passed by the Western Information Commission. So you have got
all the answer script we have got. But pursuant to manual direction, I have effected service upon the alleged contempt.
Matale. अरे वो ले ना affidavit of sir वहाँ देखो ना. The petitioner has filed the present contempt application on the allegation of violation of the order passed by this court dated 11/11/2025. Full stop. Counsel for the petition submitted after filing of the contempt application, comma, the respondent or the alleged contemptors so complied with the order passed by this court. Learned counsel appearing for the alleged contemptors have filed 2 reports, affidavit of compliance, and submit that the affidavit, the order passed by this court has been complied with. The petitioner has already full stop. Considering the above, this court find that the respondents are already, the alleged contemptors are already complied with the order. Nothing remains in the present contempt application. CPAN 256 of 2026 is disposed of. A rule, if any issue, be discharged. Affidavit compliance be kept with the writ. Next.
My lord, item number 12.
क्यों एक साथ आया? Item number 12, you are there. Call the item number 12. वो तो अलग है. होता है item number 12. 256 हम dispose of करा. Where is the contempt? Item number पहले कौन सा item बोला आप?
That was 11.
11 is where is 11?
11 is going to track कर रहा है.
अच्छा total अच्छा application. I am asking very different contempt application. Where from you have taken the training for stitching all these things? Affidavit of compliance दिया. अभी affidavit compliance फाइल किया तो वो दो. Oh. उतना ना 256 हो गए ना 168 हो गए ना. CPN number 168 of 2026 in WPN number 103 is disposed of. ठीक है रूल एक्ट रिकॉर्ड कर 256 CPN Where is 250? The petition has filed the present. This is also does not been complied with.
Yes, my lord. Complied with on 5th March.
You got that.
Yes, my lord.
Learned counsel for the petition. The petition has filed the present contempt application on the allegation of non-compliance of the order dated 11th of November 2025. Full stop. He submitted after filing of the contempt application, the alleged contemptors have complied with the order dated 11th November 2025. In view of the above, the CPN 256 of 2026 is disposed of. Full stop. Rule if any stand issued. Next.
May I please respond number 9.
Yes.
My lord, your lordship recollects, my lord, your lordship was kind enough to hear 2 writ applications analogously, and thereafter, my lord, was pleased to, my lord, dismiss the applications on 7th of April of this month. And my lord,
Just a minute. एक तो मेडिकल का था ना जिसमें रिपोर्ट बनाया था 1 बजे रखो कब था? हाँ 1 बजे का है स्पेशली फिक्स है. Yes.
my lord, I will beseech your lordship to kindly come to page 29, where your lordship was
Can one
I'm so grateful.
page?
Page 29, my lord, this is what your lordship's order was.
Page 29.
Yes, it starts. Annexure B.
Yes.
My lord will kindly straight away come to paragraph 17, as your lordship's observation was. Has your lordship got it, my lord?
Yes.
As regard to the conflict of interest, the petitioner has only submits that the private respondent number 9 is the staff of Bangla Dairy, but the respondents have denied the same, and the petitioner has not disclosed any documents to establish that the respondent number 9 is involved in the project. Thus, mere on the allegation, the selection process cannot be satisfied.
Yes.
Now, my lord, most respectfully, I am submitting. So far as now, if your lordship takes the writ application, my lord, on that particular day, while I was submitting, my lord, I had drawn your lordship's attention, my lord, to the my lord, paragraph 13 of no, the paragraph 14
Of the writ petition.
Yes. These 2 paragraphs, and thereafter 17 and 18 I have.
Paragraph 13, the father of the petition was having license.
One of the preferential rights.
Correct.
Now, my lord, kindly comes to paragraph 17. This was an avowment, my lord, affirmed through an affidavit.
Correct.
Paragraph 17. Yes. The petitioner states that the respondent number 9, being the husband of the respondent number 8, is a distributor under Bangla Dairy Limited covering the entire Salt Lake zone, and as such, the respondent number 9 has a lot of influence in the area, which he is exploiting by constantly harassing and threatening to oust the petitioner and her father. But this is in respect of the EOI where conflict of interest. But what I have learned in my last 26 years of practice, but whether I lose or win, but it is not the case. But when I am an officer of the court, either I'm this side or that side.
Yes.
But I have the privilege of being that side also, so I know. But it is my duty at least not to mislead the court. What my learned friend was doing on that day when I was referring to these paragraphs, well, that this cannot.
Correct.
Now, my lord, I have come through this application from where your lordship will find, and your lord kindly takes the application now, that present recalling application, my lord. Your lordship takes the annexure C, my lord.
Yes.
Now, my lord, kindly comes. Page 39.
Yes.
Your lordship sees in the bottom, my lord, one day food center.
Yes.
And my lord, the entire AE block sector 1.
Yes.
This day food center, the proprietor is private respondent number 9, who is the husband of the private respondent number 8. Now, my lord, I just pray to file a supplementary affidavit. What has happened, my lord? It has been mentioned in the application that these documents have been relied, but for the mistake, inadvertent mistake, I apologize. Go down to your lordship, my lord, that another 2 documents which were there has not been, my lord, annexed. So, my lord will kindly take this supplementary affidavit, from where it will reveal, my lord, the trade certificate. So, my lord, the conflict of interest.
Have you filed the supplement?
You know, I'm just praying that so that it is not sure with you.
Yes. Have you served?
Yes, yes.
No, no, no.
Also,
Sir,
that
sir,
copy
sir.
has not been served, I'm serving. Please,
No, yes.
please.
But Lordship, earlier Lordship, that application
Sir.
filed on Friday, but now it is served.
No, it has not taken on record. You have objected.
My lord,
Not served.
it was not, until unless it is not admitted, no legal.
Okay. Please.
I'm sorry. Now, my lord, kindly দিয়ে দিয়েছি, আপনাকে দিয়ে দিচ্ছি। দিয়েছি। Kindly take the annexure, my lord, C.
Yes.
Your lordship gets the name of that particular gentleman, HON'BLE. Has your lordship got it, my lord?
Yes.
The proprietor of Day Food Center.
Yes.
So, my lord, Day Food Center is the distributor of Bangla Dairy Limited, from where the private respondent number 8 is the wife, and she has been given this licensing. So, my lord, straight away, as per their rules, one of the general terms and conditions, the conflict of interest, but she cannot get this.
Yes. Yes.
Now, my lord, kindly comes to paragraph 23 and 24 of this application which I have filed.
23 and what application you filed? Recording of the order?
Recording. But this, what I say, my lord, that the applicant states that in paragraph number 17 of the order dated and such, your lordships was pleased to record that the applicant has not disclosed any documents to establish that the respondent number 9 is involved in the project. Thus, mere on the allegation, the selection process.
Page, where we are in it?
Page 10. I'm so sorry.
Yes. Continue.
Paragraph 23.
Yes.
The applicant states that in paragraph number 17 of the order dated such and such, your lordship was pleased to record that the applicant has not disclosed any documents to establish that the respondent number 9 is involved in the project. Thus, mere on the allegation, the selection process cannot be set aside. The applicant states that on 8/4/2026, the applicant herein came across such memo issued by the respondent number 4, wherefrom it is apparent that the private respondent number herein 9 herein is a distributor for milk and milk products produced developed under the brand name of Bangla Dairy in the area of Salt Lake bearing code number CNK14 covering in code such and such.
Yes.
Clear cut. But my humble submission, today when my learned friend comes before this honorable court saying that these are the marks, and it had fallen from my lord that 28 given my all three. I have been also delivering lectures in college and I have the opportunity of correcting papers. It is never a case that all the examiners come with the same marks. Anyway, I'm not going to that. He has to answer.
Yes.
Points, my lord. Why? What made him mislead the court when I was
Okay.
Let him. Yes.
But here, let's see, my learned friend says, if my learned friend don't know about the law, staff and agency, what is the difference? But the first is the recalling application is not maintainable at all. Kindly see the performance. Kindly see
Cost
the
item. Yes.
cost item.
Yes.
Cost item.
Cost title of? Cost title of?
Cost item is the recalling application.
Yes.
Here not see cost item in the petitioner application. That is the reason. I am not coming Lord. That I will thereafter Lord said the applicant the proper form. Thereafter I have cited for example, but recalling application will not maintain it. When Supreme Court said, our High Court also said, when the writ petitioner disclosure, we cannot happen at a disciplinary application. Here, Lord, I have cited the judgment of Supreme Court also.
Citation double.
Recalling application is not maintainable at all.
Please give me the reference.
Reference is the High Court.
Unreported judgment, give the copy.
Whether it is unreported.
Unreported, but Supreme Court reported here. I am giving this Calcutta High
No,
Court.
that is what I'm asking.
But you say this time.
You are a master of law.
I am the court of
You have misled the court.
Yes, I am. Lordship, here, Lordship. Kindly, Lordship, I am not the only.
First you go out from the court, fight in the ground and then come.
I'm sorry.
You will appoint one referee who will do when he will come.
I understand. I apologize. I deeply apologize. I'm going to
Yes.
copy the notice. I'm so grateful.
Lordship, here, Lordship. Kindly see the Lordship. Paragraph Lordship 5. Page 2, paragraph 5. And earlier Lordship, the paragraph 3, Supreme Court judgment has been cited by my Lord. Paragraph 3, some Supreme Court judgment is here. That Lordship 8 to 9 lines. Thereafter, the three scope of the use of the recalling application of the acquisition of the case of credit in support of the petition, he derived the following judgment, such and such judgment. Thereafter, what is state computer
Supreme Court judgment, paragraph
5.
Completely different facts and circumstances. But a change of advocate. What is he saying?
Yes, next.
Next, Lordship, I am coming. Right?
Page 19.
And page Lordship 19.
Paragraph 4. Page
Recalling application, page 19.
19, yes.
Kindly Lordship, the paragraph 4. Conflict of interest. Candidates shall not have a conflict of interest. All candidates found to have a conflict of interest mentioned below will be disqualified. The decision of the competent authority will be the final.
Yes.
Candidate in two or more different affiliates of the controlling shareholder in common. The candidate, including their personal and sub-consolidation, they have the business of family relationship as defined under Company Act 2030 with any staff of the banker diary. Staff. Not for the agency or distributor. My learned friend also a distributor. Other. Other of the Lordship.
I'm sorry, my lord. I'm not a distributor. My father, I was a licensee. I'm a licensee.
Here is staff. I am giving you, Lordship, what do you mean by staff and the Lordship employee?
Yes.
Kindly, Lordship, I am talking about 1 to 5. What is Lordship kindly staff definition? The one staff. What is the definition of the staff? Staff means Lordship employee, not for the agency. Staff Lordship can go.
Yes.
That is my service. Here, Lordship, I am telling Lordship, the petitioner Lordship got the model period code Lordship. If the Lordship panel, if the Lordship I am not succeeding my method for succeeding the resolution. He did not Lordship. That is my suggestion for Lordship. Not maintaining it and staff of
Well, may I have a right of reply?
Yes. Yes.
First of all, because unsuccessful. Successful. So,
When they come to the conflict of interest. Yes, read it.
You're a lawyer.
Let me see.
Correct. No, the candidate that has a business or family relation that is out. Under with any staff who are directly or indirectly involved in this project. What is the project? Retailership project shall not be considered for petition. Now what you are doing? Let me see. What is the distributor? What distributor you are? Now come to that. Where is the 37? Yes. 37 of the yes. Bangla Dairy with Day Foods. Correct. And yes. So this is of the you are the distributor of what? And what is the project? What is the project? Correct. What is the project and what is the distributor? Tell me.
I'm distributing the goods.
What distribute? What is it? You are also distributing the milk. The distribution of the milk also under the project. I am not in the retailership. I am on the project. Kindly see where the retailer it is mentioned. Kindly come here. B. That's why I'm asking. Read the B. Read the B. The candidate, including the personals or sub-consultants that has a business or a family relationship with any staff of Bangla Dairy Limited who are directly or indirectly involved in this project shall not be considered. So this project, what is the project? That's why you explain this. What is the project?
Two projects are different. I appreciate. I am a distributor. I procure materials.
I am only asking the project. What is the project?
Milk product.
Milk product. Milk product. So you are the distributor. Milk product, you are a distributor. The
Other products also. I procure materials from different other brands. That doesn't prevent me from procuring milk products.
so let the court and the court is very full. Not understanding. That's why I wanted you have to understand the court. You are very fast. That's why you are the distributor of the milk. And the EOI has been issued for the retailer of Bangla Dairy what? Milk. Who will distribute the milk? Bangla Dairy. Bangla Dairy distributor. Who is the distributor of the Bangla Dairy milk? So it is not an interconnected project. Let me. Then I have to about you also. Tell me. You are the distributor. So you are also distributing the milk. Correct. So distributing a milk and the authority have issued the EOI for the retail shop. Retail shop of the milk. In the retail shop, who will distribute the milk? You will distribute the milk. Then they will sell in the retail prices, in the retail shop, in the retail counter. So it is not interconnected. Tell me. That is subsequent. No, he is smartly telling that. That's why I'm asking. Let the court understand whether it is not interconnected. Yes, tell me. Why you are taking the shelter of the connivance? Don't do.
Court has the question to you. Tell me if the retailer selling of the milk by the retailer or selling of the milk by the distributor, whether this is not the interconnected.
Distributor purchase the milk from mother, from Bangladesh.
Correct.
I mean,
So you're not changing the mother dairy to the other brand. You're not changing the, you're taking the mother dairy milk in the wholesale.
yes.
Correct. And you are distributing to the all retailer shop for daily selling.
Yes.
Correct.
No, I am not engaged the retailer. The retailer has been engaged by retailer.
This court find that the recalling application is to be heard on merit. Full stop. The parties are directed to file affidavit in opposition within a week. Reply, if any, they have to be filed within a week thereafter. Please the matter on 7th May 20, no, 1 week, no? आज कितना तारीख है? 30 तारीख. Please the matter on 14th of May 2020.
May I only pray for one indulgence? I'm sorry, my lord. Your lordship knows that your lordship was kind enough to give me time to stay my lordship while dismissing my writ application. So your lordship kindly.
Let the decide. If they decide, then you will get the benefit. If it will go in your favor, you will get all these things.
One indulgence to address your lordship out of turn. I'm sorry, my lord, in that matter, Junior had said that we will not take coercive action if you don't come. I don't know what she meant, but it's actually if you now, and if you don't.
This court has recorded that on instructions he submit that no coercive action will be taken as per the so-called notice issued against the petition. I have already recorded this report. The court has not passed any interim order. Only I recorded that as per the instruction, no.
Kindly, my lord, she's very young, 6 months only.
I will see.
Let's protect us.
I have one prayer. Only to disturb your lordship, I have one prayer. Possibly your lordship is aware there is a resolution on the bar. That after 2 o'clock, in lieu of the election tomorrow, if both sides do not appear, not to take it.
No, I will not take. If both I will not take if both the party will not appear.
I would have also not.
Lord, I have taken I'm sorry to disturb. I've taken instructions. Till now, if you haven't come, we will not take steps. If you come,
I will take note of it.
Mr. Chaudhary is now realizing the fun of appearing for the commission, which for the state commission I had appeared for more than for long. Now
I was getting into trouble with the division bench also. I said the commission should be more careful. I said that's what I've been hearing from 10:30 in the morning. What's the same this?
I just wanted to mention next matter, item 14. Lord, in that matter, my lord, your lordship is also made a party. Respondent contempt. Somebody is appearing in person.
Not only the lordship.
I have been made a party.
My lord,
The total government of India.
Yes,
Yes.
President of
my lord,
India.
I thought, my lord, why Donald Trump has not been made a party. I felt
As an order.
But unfortunately, this was appearing as item number 106 yesterday's list. Today has come.
Application. It was application. One day I am taking the application first. Second day I am taking the urgent motion first. So the application just come out.
This type of petitions were earlier moved. Then the Honorable Chief Justice dismissed with cost.
So that's why I am referring this to the Chief Justice.
The homeopathic doctor is doing all this.
I will refer this matter to the Chief Justice.
Yes.
oh, we all are parties.
That's why all our parties, including the President of India and Prime Minister also.
Yes,
I will refer the matter to the Chief Justice so that it may be taken as a pill and he will take whatever.
That is the thing.
Yes, that is
a pill. Kindly see the prayer.
Or that your lordship wants you to refer it to the rules from the High Court. Okay.
that matter be taken up today or my lord, any day.
Then this honorable first, no.
I will. Because one urgent matter is there, one doctor reports is there. That I will take. Yes.
Item number 6.
Yes. Report.
The board has We have examined the petitioner. I mean the. So this is the report. This is how we done. If is done, will be he is going to suffer morbidities. He is going to.
Yes, have you gone through?
Well, I just received a copy. Well, paragraph 2 says that if termination of pregnancy can, in the last line, the last sentence, if termination of pregnancy can be delayed at least for 3 weeks, the complications of the newborn is expected to be much lesser than the termination at the present stage. Well, here, the word baby has also been used. Newborn has also been used. Baby, refers to the fetus. I think. But in that case, if the harm is to the fetus or the newborn, then the victim girl has a right to terminate. If would have been other,
They have a right to terminate unless and until the board of doctor confirm that it is possible.
It is possible.
It is yes. It is not mentioned. It is where is it is mentioned. It is possible. Can you see read the total paragraph 2?
Yes.
In case the baby will born premature, if termination is done now, in spite of all
necessary resuscitation and care, the baby may have various short and long-term.
There is some problem.
If it is terminated, this is for the baby. 3 is for the mother. If induction,
3 is now come to the 3.
Yes.
If the induction or labor done, the possibility to need the caesarean section and which can be lead to modality, the termination of the baby lead to. So why see? Why it let it be born and it may be given to the
paragraph 3 word goes against me. It is actually against the victim.
Both has to be read together, 2 and 3.
2 and 3 have to be read together.
Read together. What do you want? Consult.
But parties will not, the guardians have been counseled.
Yes, inform.
But one thing that custody of the
that's
that will be my subsequent.
That's what I'm telling. If it is not possible, let the baby born, and the hospital will take, and it will be given to the.
Yes, if it is endangering my or my daughter's life, then it makes
You
no
do
sense.
one thing. I am keeping this order. You consult with your concern. Then
I shall.
Order because it is not possible for the.
I also feel
this
so.
court is also not suggesting.
No, I also feel so. If it is only for the baby, then the mother could have a choice. But here, but both.
Maximum mother.
Yes, profuse bleeding and
32 weeks is much higher side.
Yes, but still, the
24.
Supreme Court is allowing.
Supreme is supreme.
But here I am carrying judgment which has reasons, reproductive
that's
autonomy of the mother. Everything has been discussed. And when it goes
in that case, then all the things the mother has to examine further.
Yes.
With regard to this and other thing, then the report, the whole and the Supreme Court which you are referring, the total report was before the Supreme Court.
Yes, that was there.
Total report was the Supreme Court. Then the court has considered and board also assured that yes, it can be.
They will take so. Supreme Court even has gone to the extent of saying doesn't matter. Life of the fetus mother doesn't matter. Mother's choice to terminate. That's all.
Not by this court.
I understand. Lordship may keep this matter
after
or tomorrow. Kindly takes it tomorrow.
Tomorrow you come, I have no problem. But
my senior friend. I'll be there.
The Advocate General has filed the report after serving the copy to the learned counsel for the petitioner. The petitioner prays for time to take instruction. Let the matter appear tomorrow. Under the same matter.
Item 14.
Yes, item 14.
16 of election.
Just a minute. Item 14. Yes, so you are for the petitioner. You are appearing in person. Yes, what is your grievance? Kindly come to the prayers. What is your grievance in the prayer?
In respect this can number 1.
Now, kindly come to the first writ petition. What is the grievance in the writ petition? I will come to the can 1 subsequently.
I haven't bring the writ petition.
For the last 5 days, you are mentioning the matter.
I am.
Yes, what is the can? Okay, let me understand the can. What is the prayer in the can?
Prayer in the can is want to issue the writ of mandamus, but I would like to take the matter that Your Honor is the respondent number.
What is your original? What is your grievance? Actual grievance? What is your grievance?
From 2014,
Ah,
I am out of my home.
huh?
Out of my home. And my my home. Yes.
Yes,
My residence is at Habra Bedroom.
correct.
Several order was passed by this Honorable High Court.
Mm.
The state have thrown all of them
Mm.
without any contention. If
Hmm.
they have any contention, they can.
Mm.
On 2019,
Mm.
the Dakati was made.
Huh?
The Dakati.
Dakati.
The Dakati was happening.
Mm.
2019. For the sake of humanity, I have handed my key to the police officer
Mm.
to stay in my house.
Mm.
And thereafter, I haven't haven't returned my.
So what is the prayer now?
To provide me
So
first.
why you made all the authorities or all the as a respondents?
For this last 14 years.
Huh.
And next.
Let the President Honorable, can you know the, can you make the President of India as a party to the writ petition? Yeah, Prime Minister as a party to the writ petition?
I have
Judge of this court.
asked,
And the judge of this court.
the respondent.
Judge of lordship is also made a party. Ask for the 18.
That is different.
The Honorable President was treated as a respondent to give respect to the Honorable President. Because I cannot meet the Honorable.
So what is the prayer? What is the prayer? What is the prayer in the can?
18.
What is the prayer in the can?
18 letter was sent by the Honorable President, was disregarded by the state within 1 year.
What is the prayer in the petition? What you prayed for?
They prayed for to file a FIR as per the procedure of the law. The police file a FIR against the culprits. The SLSA and GLSA will provide the necessary legal aid. 5 directions.
So this court, how this court can consider? And why this court has been made a party? What this court has done with your property or with you?
I have
whether this court has went to your property,
no.
Then, or whether this court has committed any with you, committed any offense with you.
No.
Then why you made a party to the not me, other 2-3 judges? Why?
That was I stated in my petition.
Why? That's what I'm telling. Why?
Because I
in the writ petition, I am not a party. In the writ petition, I am not a party. In the can, you have made a party. Show me why you have made a party. Otherwise, I will pass appropriate order.
Alleged contempt.
So, why you have made a party to this court in person? You satisfy this?
When I filed this petition, this petition was when this petition was filed. It was filed on 7th.
7th of?
7th April.
Correct.
And thereafter I was stated that everything was compiled.
Correct.
And they have direct me to do some correction as a petition person.
Correct.
I have made some correction to satisfy the court.
Correct.
After that, when I am going to serve the notice, I find that the number which was given to me is not according to the number. So I searched the internet and found that the case was not in the list.
Correct.
There I haven't received any instructions. So again I come and I see that it is in the defect list. And what is the defect is nothing but one number. So I again come before this court
Office.
and to make the change. And one thing they cannot satisfy me. The number,
that is another thing.
The number.
So why the court have made a party?
I am going. The number which I gave in in the first petition, it was accepted. If the number, why this number was changed? So 7 days already go.
Which number? What was the number your writ petition earlier? So that subsequently it was changed. What was the original number?
That number that I haven't come with.
So,
the number is
you are making the allegation. Earlier one number was given in the writ petition. Subsequently, when you have noticed that number is not there, then the department.
Number was changed. They said
That's right. What is- show me immediately. I will make an inquiry. I will fulfill your grievances here in now. Show me the first number of your writ petition, and the officers change the number of the writ petition subsequently. Here in now, within 5 minutes, I will inquire into the matter. Show me.
Possibly, Maharaj, he has conflict between filing number and the petition register number.
Show me which number you are. That's why I'm asking. Which number you are asking that first number?
1745 of 2026. This petition was filed on 22nd, first
Check karo. 1745. 1745 of 2026.
WPA.
Where from got that number?
That is in respect of mentioning before the.
Mentioning you are mentioned. Where you got that number 1476?
It is the 1745. This is the running case.
No, who gave you the number? Is it for department? Filing section? Where from you got this number?
That writ petition is another pending before the another court.
The number in the book, in this phrase, there is the application type code. So there is only.
What is happened to 13 February? See?
And
just a minute. That matter was appeared before the Justice Ghosh on 13 February.
Yes.
Yes, you had appeared. 13th February 1746 has appeared before the Justice Ghosh.
45.
Yes, 1745. It was appeared before the Honorable Justice Ghosh.
No, 45. It was not in the list.
Where is the order?
Till now, it was not in the list.
See, sir, if you're not able, don't file all these things. You will be in trouble in my court.
1745.
Yes, 1745. You have been directed to serve the copy of the application on 5th of February.
This file was not in the list.
What are you telling? See, what is there? Which court?
No, this is not in the list in any court. The matter is going on. The
5th February ka causes nikalo. See, I am inquiring here and now, then you will be trouble.
Is the Can 3 2000
1745 was listed before the Justice Ghosh on 5th of February. The court has an order. I will call the record itself here in now.
This is police in action.
5th February.
In this matter, the honorable, the direction of the honorable court is on 10th March 2026 to the Mandamus section, given by Honorable Justice Saugata Bhattacharya.
When?
On 10 March 2026.
5th February, it was before Justice Ghosh. Then it was fixed on 13th of February.
Yes.
And then what has happened?
The Honorable Justice.
So how you are telling the number is changed? This is a new number. This is another writ application.
It is another writ.
Then you are.
No. I felt to. This is my fault. There is a number. This is application code number. That number, which I filed for the writ petition previously.
Code number.
That is code number. Who has written that? Who has written that code number?
That this is my.
Yes. From where you have written?
I have written from. I asked them and write them
Hmm.
because I don't have all these documents and everything. So recent documents, and as a petitioner,
So why you have made, why the can application?
the CAN application is for this, that after that for more than 1 week, the matter was not filed, and there is some urgency to go and visit there to for the elections, and thereby I have also filed a CAN in respect to this, that the FIR was also not taken by the Govardhana.
Sir, I am asking one question to you. Why you file the can application by making this court as a party? You satisfy me, then I will pass appropriate order. First, you satisfy me why you have made this court as a party to the can application. If you satisfy this.
On 16, this case was appeared before this honorable court.
16?
16 April. So,
Correct.
and I appear as a person before this honorable court. And I tried to mention to about the matter. Your Honor have stated me to file the to file a mention, and I have mentioned. And Your Honor also directed me to provide the urgency.
Correct.
I have written this in hand.
Correct.
And thereafter I wait.
Correct.
And when in evening I came back, I find no officer. I find nothing for the mention.
When you mention?
I mentioned early morning.
When mention? Which date?
16.
16. See the diary of 16. Mentioning diary, see the 16. Where is your mentioning list? Diary check karo. Then what has happened? So the list was not there. Then?
So, and I was in.
So every day all the petition will come with a contempt application against Justice Krishna Rao. Because the mentioning list was there, but it has not been listed.
And I have stated that as per the procedure of the law which was provided, that should be listed within 48 hours. And it was not listed, so I asked for the reason. And
from whom? From whom you asked for the reason? Huh?
From the office. Court officers. So what is the procedure? I am new in this court. I do not know. So it was said that it should be. It should be as per the wish of the honorable judges. That when the judges feel, the case will be fixed. So thereafter, on 17th, I also mentioned. But Your Honor have refused me and give leave to some others. And this is the election matter. I don't have a time.
Correct.
So because the even today the release, I think I do not get a chance to.
That's why I am telling you, satisfy why you made this court as a party in person. I will release the matter. And if this court will satisfy, yes, this court has done something wrong, and you have a cause of action, I will release. The appropriate court will decide. That is the simple thing. You show me what is the cause.
And the cause is this, that I have in this.
Yes, you have kindly see. Kindly see. You are mentioning list. You are telling that you are not. Kindly see. I already specified the date when it's to be listed. Kindly see. You are mentioning list.
But that I was not informed from this court.
You not all the advocates are getting that. Kindly see. I am not still until I have not taken the pen. Kindly see my writing, and I have fixed the date on 23rd April.
But I was not communicated.
It is not. You have to come here and to check the diary. You come.
That day.
वो कब का लिस्ट है? कब कर रहे हो?
23rd April.
कब mentioning है? 16th April.
Yes.
So 17 or 18 you came here.
I have filed this on 17th.
Okay. Look, अभी हम इसका बजाते हैं.
And it was stated that.
Yes, show me. It is the cause of action. Show me the making this court as a party.
Yes, I in this mentioning the part 2 I have stated that I demanded my right to justice shall be respected and secure without any further
Sir,
charge.
I am telling, show me the cause why you made this court as a party to the writ petition and the can
I
application.
am stating that.
Where is?
I have
Page number?
it is page number 58 and
Page number 50. Yes.
and page number 56. Notice was sent to your honor that I demand on 16.
Notice was sent to whom?
Your honor.
I am not having any this email. The court is not taking any email of the private parties. You send this email to the private to the court. Is you? Who has authorized you for sending this mail? And have you checked the mail has been delivered to me? And how you came to know this is the email of this court?
It was published.
This court, number 25.
That was not done. So I have asked for the email as per the
order. Petitioner is appearing in person, full stop. Petitioner has filed the writ application being 8996 of 2026, praying for the following orders. Praying for the following orders. Record. Where is the prayer in the writ application? Going order, page number 99. Just a minute.
I will provide the
page number 99 to page number 109. Full stop.
The court have violated the act.
Subsequently, the petitioner has filed an application being Can 1 of 2026 on 17th April 2026 by making this court as in-person party to the said application. In person to the this when the matter is taken up for hearing today, why this court has been made? This court has party respondent in person, comma, the petitioner submits that after filing of the writ petition, comma, the petitioner has sent an email addressed to this court. In the email address cj-wb@nic.in, comma, rghc_cal@rediffmail.com praying for listing the matter urgently. He further submit that subsequently on 16th of April 2026, he has made a mentioning before this court by giving the mentioning list before this court, but in spite of receipt of the mentioning list, comma, this court has not fixed the matter. Accordingly, the petitioner has filed the present application by making this court in person as party and praying for the following order. Paragraph page 27 से लेकर के page 35 जितना prayer है सब कर. This court has called for the record. This court has the officer of this court has brought to the notice of the mentioning list filed by the petitioner on 16th April 2024, and it is found that on receipt of the mentioning list of the petitioner, this court has categorically noted in the mentioning list be listed as urgent motion -1 on 23rd April 2026 within 10 matters. 10 matters. Without police, in spite of having the knowledge, the petitioner has filed the present application. Thus, the petitioner has deliberately and willfully made this court as the party respondent in the CAN application. Thus, this court is of the view the rule is to be issued against the petitioner. Why the contempt proceedings shall not be initiated? Let the matter be listed and let the matter be placed before the Honorable Chief Justice for constitution of the special bench to hear the matter along with the.
Your Honor, I was not concerned about your order. No, please keep it in the order. No, I am not concerned with the order. Your order is kept in the file, and nobody has communicated the matter to me.
What is the matter? What is the matter? What is the matter?
Your Honor, if
The matter?
get the chance,
nomination paper filed by the petitioner.
ए, एक तो जेरक्स करके इसको संभाल के रखो, कहीं फेंक मत देना, और एक मेरा ऑफिस में।
Lordship, request you to kindly
Yes.
note my appearance. I'm led by the learned ESG.
No, it was considered.
Your Lordship, it is looking to returning officer's conduct. I have got the report. Your Lordship had directed for a report. May I hand over a copy of the report.
Item number?
Item number 3.
Come at 2, come.
Yes, Lordship will come.
Your Lordship, 2 p.m. Chief Justice has fixed a matter.
No resolution.
Yes, this is too much. Court is working till 2. What for the recess is there?
If the court has been made as a party to the writ petition, the court has to take on.
Court is court. Don't mix with the others.
Yes.
Let the matter be called on.
Yes, call the
But one indulgence, in respect of item 20, in respect of item 21, your lordship was pleased enough to grant leave. There is an urgency in the matter. If your lordship
calling the list.
will take up the 2 p.m. Yeah. So
কি matter আছে কি? কি আছে?
ওরে চলবে না 1 মিনিট চলে তুই শোন না
লিভ না আমার লিভ না এটা আবার এও ফাইল করতে হবে
হ্যাঁ 18 অবধি
Who is appearing?
15 থেকে
Next matter.
115 to 121.
You are appearing.
Today my lord is relieved because the intimate will be extended. The respondent who has required to file an affidavit has not filed.
Lordship,
Close.
Lordship, I appear for
Filing
the
affidavit and writ petition allowed.
The first point will be appeal court. My lord, there is no scope for filing affidavit. I am gone.
Written.
Lordship, I am appearing for the
Handling of writ petition helps nobody.
Lordship, I am appearing for the Central Pollution Control. I need to file my affidavit in opposition, Lordship.
কপি দিবি না
দিয়ে দেবো সব দিয়ে দেবো স্যার
Yes.
করে দিই সব দিয়ে দেবো তারা বলছি তারা অনেক
Don't be afraid of seeing the point is very simple. Hard.
ডায়মন্ড আর এগুলো অনেক আগে হয়ে গেছে আমি খেয়ালই করিনি যে দেওয়া হবে ABD.
Not going to the merits of the case, whether CRC.
Okay, you are filing.
I am for Central Pollution Control Board.
Respond number.
There are various respondent number. I mean, in one matter I am 28. In one I am respondent 6.
Pollution Control Board.
Central Pollution Control Board. Central Pollution.
appear for the State Pollution Control Board.
You filed.
We are the
তোর মামলা করবো তোর মামলা তো সেদিনে ও এইটাই তো না
On the one, my lord,
দিয়ে দিয়েছো
item number 11116,
দিয়ে দিয়েছো
not file this report form of affidavit by the state, my lord. Because one of district magistrate will file this, not kindly, my lord.
Well, may
please extend
I
time.
pray this? Well, Lordship will be Lordship will be obviously extending the interim order. But in the meantime, those who have not filed may file, subject to Lordship's pleasure.
Respondent. The Central Pollution Control Board filed
নিজে ফাইল করে নিজেই ভুলে গেছি
affidavit in opposition in all matters. After serving the copy to the land counsel for the petitioner, let the same be kept with the record. The land counsel for the state in WPA number.
WPA number.
কোডটা বল
Policy number 20015 of 2025.
0015/2025 praise for extension of time to file affidavit in opposition.
কোনটা ফ্রি পেয়ে যেতে
Affidavit in opposition. Let affidavit in opposition be filed within 2 weeks after serving the copy to the learned counsel for the petition. The petitioner is liberty to file a reply to the affidavit in opposition filed by the Central Pollution Control Board as well as the state, if any, within 2 weeks thereafter. Full stop. List the matter on. Give the date.
Date ball. Any day suits, my lord.
না না ওরা দিচ্ছে
Any day suits.
1st July.
After vacation.
1st July.
1st July.
1st July at 2 p.m. as a specially fixed matter. Interim order is extended till 3rd of July 2026 or until further order.
at least 1 week
1st July, 10th July.
1st July will be taken up. That's why chance will be 1 day given extra.
এখানে হয়ে যাবে
May I please say
তাহলে পাঠের করাতে হয় no that is why I made the submission my lord anybody who has not filed
one will do entire matter
anybody who has not filed
No, Kardo. It is further made clear that
all the matters
anytime if any of the respondents intend to file the affidavit in opposition is filed within 2 weeks. Reply if any that
তোমাকে
is-
বলে এসে দিয়ে যাবে all the matters same
this side matter my lord is well acquired on very
Mandarmani.
area Port Blair HON'BLE C, and here we have this.
This one.
Mandarmani C. Not this.
All.
Mandarmani C. C.
Same C. Way of doing.
Same C is coming.
Same C.
Okay.
All matters are analogous matter from 115 to 120.
Yeah, that already passed an order.
Yes.
First, I go to the photo.
18 দিল তো
18.
Analogous matters कितना है? That's all. Why you are calling all?
all.
If left to Mr. Basu, the canal, you said my house will also become the same C.
Same.
Now the Andaman authority will remind Mr. Basu so the ticket, whether he will get the ticket to go to the Andaman.
Yes.
Sir, he has bought a.
No.
Island.
So you people don't know.
Not an
Once he
island.
appeared in this court, I
No,
said,
I
you have
know.
visa.
Brought an island.
What
Now I-
pilot
now
doesn't know, I
DLT
need
said.
to tell him.
It's brought an
He's the
island.
greatest miser on earth.
তুমি island কিনেছো?
Oh, this is a compliment to me.
Island
I take it as a compliment.
Beyond world island কিন্তু।
Yes, next.
আমি 16
16. Yes.
My lord, my learned friend has filed a report, your lordship, that is before your lordship.
Where is the report?
It is before your lordship. My lord, it is alleged out here that Form A and Form B has not been filed by the petitioner. And second, your lordship, that revised affidavit, because affidavit, there are some lacuna. I was directed to file the affidavit, your lordship, revised affidavit, that was not filed by me. That is the allegation, your lordship. My lord, kindly look into this. 8, on 8, the nomination paper filed. And there is a checklist wherein I was said that Form A and B was not filed. And I was directed to file a revised affidavit. My lord, the checklist.
So what is the prayer? What is the prayer in the writ petition?
Writ petition that my name of my political party should be taken into consideration. They did not consider it, your lordship. I was considered as an independent candidate.
Your lordship, at this stage, when ballot papers have already been issued,
My lord, kindly, your lordship, kindly take 18 first, page 18. 8, nomination paper filed, and subsequently, your lordship, this checklist was taken into consideration. This is on 8. My lord, serial number 3, Form A and Form B not submitted. And the last one, your lordship, Form A and B should be filed latest by 3 p.m. on 9/4/2026. And the next page, your lordship, revised affidavit should be filed latest by 3 p.m. on 9/4/2026. The document I had submitted before lordship of 9th of April to 2026. One-page document. At the first page, your lordship, at the top, it is stated that revised affidavit being filed. Can you look into it? Right-hand side, revised affidavit. And with regard to your lordship, Form A and B, that also submitted.
What can be done at this stage once the ballot papers has been ready and it has been dispatched? What can be done?
But this is the action, my lord.
Correct.
How they have acted. My lord,
I will decide, in that case, I will decide the matter. If they find, then the appropriate order will be passed.
your lordship,
Let they file the affidavit in opposition. If you want that, then the court will pass the appropriate
My
order.
lord,
If
let there
this
be a
court find
direction.
that due to their fault, you could
My
not,
lord,
you could not be recognized as a party
it's
candidate.
not that, your lordship. My lord, everything was there in the report, your lordship, for that.
Correct. I
that is-
appreciate you have been authorized by the one political party and there is a certificate, but the returning officer has not considered. I appreciate.
Yes.
But at this stage, the ballot paper has already been printed. So how the court can pass any direction today?
My lord, look into the.
postal
I could
ballots
make
have
out your
started.
lordship.
It's not that only
I
ballot
could make
paper.
out your lordship, but still, your lordship, what I
Voting has
humbly
started.
submit before lordship. My lord, can you look into the conduct of the state?
That's why I'm
That
telling
is-
with regard to the conduct of let they file the affidavit in opposition, you file the reply, this court will pass the appropriate order on merit on the conduct. Let they face the consequences if they find the guilty.
I'll ask Pancholi.
Your Lordship, it would be done through election petition only. This is your Lordship's decision
That's
in
correct,
another
but
matter.
yes.
I leave up to your lordship. I leave up to, my lord, if there is any scope, your lordship, if my learned friend could
No,
consider.
here is
No,
not here is not the election
I've given
petition.
a wrong judgment, Your Lordship.
Here is not the election petition. He has not challenged with regard to the
No, I
anything.
didn't.
He has challenged with
I didn't.
regard to his candidature for as a political party. This cannot be election petition. This is administrative lapse on the part of the returning officer.
Yes,
So writ
I didn't
petition is
challenge.
maintainable.
239, I haven't.
So that's why I'm telling if you want, I will pass a direction for affidavit. Then your officer has to face the consequences at the time of final hearing. If you find that you have not done in accordance with
Yes, my lord, our election will be scheduled on 29th.
correct, but the ballot paper and already started dispatching.
If my learned friend could, my lord, because last occasion, your lordship, day before yesterday, my learned
Voting
friend.
is done two form. The first when we go to a polling booth and cast our vote. Before that, postal ballots have already started. People who are under army and other categories, elderly person, they vote through postal ballot.
Correct.
So 7 days from
the grievance of the petition in the present date application that in spite of the one of the political party authorized the petitioner to contest the West Bengal Assembly election 26 election election, and when the petitioner has filed the nomination form along with the authorization of the concerned political party, the returning officer, without considering this authorization of the political party, has allowed the petitioner, allowed the nomination paper of the petitioner as an independent candidate instead of the concerned political party candidate. Learned Counsel for the ECI has submitted the report after serving the copy to the learned counsel for the petitioner. Learned counsel for this ECI further submit that after completion of the nomination and scrutiny has also been completed, ballot papers have been prepared and dispatched to the respective polling booths. And at this stage, if any order is passed, it will be difficulty for the authorities for taking any action for allowing the petitioner to be the candidate of the political party. In view of the above, this court find that the petition is to be disposed of only after exchange of the affidavit. Let the affidavit in opposition be filed within
6 weeks.
Within 3 weeks, within 4 weeks. Reply, if any, there to be filed within 2 weeks thereafter. List the matter in the month of, in the combined monthly list of July 2026. Next.
My lord, the document I handed over, that is the only copy I had,
Yes,
your lordship.
You take.
Yes, lordship.
Yeah, there.
Obliged, your lordship.
17 million on the last occasion, my lord, you lordship heard the matter, my lord, directed the ECI, my lord, to file a report.
Your Lordship, I'm praying for a short passover. The report is here. My junior is unable to, if it could be taken up after 2 matters.
Yes, Pasu. After 2 matters. Next.
I am appearing on behalf of the petitioner, my lord, that matter, my lord, remember the kidney transplant matter, my lord. And yesterday matter was taken off, but my learned friend, my lord, was not equipped with the report, my lord.
Yes. I have the report.
It will be kind enough.
What is the report? Huh?
Page number 9. Can you give us page number 9?
Give the report.
My lord, please give us.
Page 9.
Page 9.
Statute available. Judicial, order, coordinate bench order. Appellate provision, appellate provision. Justice. Justice Amrita Sinha.
Yes,
My lord,
see the report.
I have. Appeal provision developed. Okay. But I have to keep the report. Which one? The contractor mobile number given to the people. I don't know what we found that the contact number is registered on the. Now the family member of the donor. So after the call.
Any final order is passed?
No, my lord.
The final order.
My lord, may I go through this report, my lord? May I place this report, my lord? What happened, my lord, in our state, my lord? The statute is very clear, my lord. The authorization committee, my lord, which is annexed with my petition, my lord, they called me, my lord, page number 40. Can I turn, my lord, page number 40? My lord, organ transplantation board, my lord, called me, my lord. That is entry 8. After that, nothing happened, my lord. No communication made by the transplantation board meeting, my lord. And not only that, my lord, if they issued any order, even against me, my lord, there is a specific appeal provision. In our state, my lord, there is no such appellate board, my lord. Section 4. But the coordinate bench, my lord, passed this order, one order, my lord. In Shahnaz Begum matter, my lord, kindly see, my lord. Are Shahnaz Begum matter? Appellate provision টা দেখো। Under Rule 33, my lord, 2014 rule bear for Rule 33. এটা রুলটা দাও, রুলের কপি দাও। In order of not even past the okay. No, reported. There is no whispering out transfer of money.
Yes.
My lord, may I read, my lord, the respective provision, my lord? That is 2014 rule, Rule 33. Copy আছে? Rule copy. Oh. My lord, may I hand it over, my lord, the rule, 2014 rule? This rule called, my lord, Transplantation of Human Organs and Tissue Rules 2014. My lord, Rule 33. Any person aggrieved by an order of the authorization committee under subsection 6 of section 9 or by an order of the appropriate authority under subsection 2 of section 15 or subsection 2 of section 16 of the Act may within 30 days from the date of the receipt of the order prefer an appeal to the central government in case of union territory and respective state government in the case of the states. My lord, kindly see, my lord, kindly turn page number 40, my lord. When they called this meeting, my lord, they called this meeting on 11th November 2025. Provisional list of patient for organ transplantation board. Yes, my lord, page 40. This is a notice, my lord. May I read, my lord? Provisional list of patient for organ transplantation board meeting scheduled on 11 November 2025. Venue Institute Building of Health and Family Welfare, Shastro Bhavan, time 11:30 a.m. Authorized person of the following organ transplantation patient are directed to attend the transplantation board meeting scheduled on 11 November 2025 at Shastro Bhavan at 11:30 a.m. along with donor and guardian. They should carry at least 2 documents of photo identity proof and address proof in original, themselves in form 1, 2, 3 of the recipient, donor and their legal guardian. My name entered in entry number 8, my lord. After this meeting, my lord, nothing happened, my lord. They not issued any order, my lord. They just orally says, my lord, kindly take my lord, representation, which is annexed with my representation page number 41, my lord. In vernacular language, may I read, my lord?
Yes.
Kidney প্রতিস্থাপন, I just read it, my lord, and thereafter I translate it, my lord. কিডনি প্রতিস্থাপন করিবার অনুমতিপত্র। মাননীয় মহাশয়, আমি শ্রী নীলিমা ঘোষ, পিতা শ্রী সুধীর ঘোষ, জিরাট হাসিমপুর, বলাগড় হুগলি 712501 জিরাট গ্রাম পঞ্চায়েতের অধীনস্থ একজন স্থায়ী বাসিন্দা। আমি একজন সিকেডি স্টেজ 5 কিডনি পেশেন্ট। ডাক্তারবাবুরা পরামর্শ দিয়েছেন কিডনি প্রতিস্থাপন না করলে আমি বাঁচব না। দাদার ব্যবসায়িক সূত্রে পরিচিত এক শুভনোধ্যায়ী আমাকে তার একটি কিডনি ডোনেট করতে ইচ্ছুক হয়। কিডনি দাতার নাম মিঠুন নাগ, পিতা শ্রী সুশীল নাগ, 19/A জগন্নাথ ঘাট লেন, শ্রীরামপুর, ওয়েস্ট বেঙ্গল 712202 বাসিন্দা। বিগত 11/11/2025 তারিখে স্বাস্থ্য ভবনে বোর্ড মিটিং হয়, তাতে 8 নম্বরে আমার নাম উঠেছে। সেখানে স্বাস্থ্য ভবন থেকে আমাকে বলা হয় আপনার ডোনার সম্বন্ধে পুলিশ ভেরিফিকেশন রিপোর্ট ঠিক দেয়নি, তাই আপনার ফাইল রিজেক্ট করা হলো, আপনি অন্য ডোনার খুঁজুন। পুলিশ আমাদের কাছে টাকা চেয়েছিল, আমরা দিতে পারিনি, তাই পুলিশ ভেরিফিকেশন রিপোর্ট ঠিক দেয়নি। আপনার কাছে বিনীত অনুরোধ, আপনি মানবিকভাবে বিষয়টি দেখুন যাতে আমি এই পৃথিবীতে বেঁচে থাকতে পারি, এই ডোনারকে দিয়ে কিডনি প্রতিস্থাপন করাতে পারি। মানে there is a specific requirement, my lord, that police want money from me, and my lord, there is no such, my lord, the rule is, the statute is very clear, my lord. The donor, my lord, made 2 affidavit which is annexed with my writ petition, my lord, page number 29, my lord. 29, my wife's, the donor's wife, my lord, her affidavit, and page number 32, my lord, donor's affidavit, my lord. May I read, my lord, both the affidavit?
Yes.
My lord.
Yes, no problem. See.
There is no expressly says that yes, there is a financial transaction. This says their family status is like so and so, but where is that specific inquiry or investigation regarding there is a financial transaction? There is no such financial transaction. Out and love and affection, my lord, they wants to donate the kidney, my lord. That statute is very clear.
That is correct, but they have to see the donor also.
Yes.
The donor condition is a daily rated mazdoor. He is earning only 1200 rupees, 12,000 rupees per month, and he is not having any bank balance and all these things. If suppose today he is donating the kidney to one person, he is only having then one kidney, so he might have faced some
My lord, with deepest of respect, my lord, the statute is.
Let the court complete. Then tomorrow, if he finds any difficulty for his health condition, who will take care of it? Because he is not having the sufficient means of this. That's why they have stated as per the report. If it is said regarding financial transaction, if it would have been said, yes, you are having the sufficient means, so there is question of taking money or money transaction does not arise. Here the problem is that see the condition of the donor.
My lord,
daily rated mazdoor 12,000 rupees, so implied.
My lord, with deepest of respect, my lord, kindly turn page number 37. the donor by the affidavit, my lord, he declared his PAN card number
Correct.
as well as his income status, my lord.
Correct.
Kindly see, my lord, the income status, my lord. My lord, that is his income status, my lord. My lord, that is not a considerable subject for the donation of a kidney, my lord. The statute is.
Sir, the question of consideration of question of saying that what will be the effect in the society. Nowadays, if kidney transplantation of the kidney, it is permissible under law. That's why a committee has been constituted. The committee has to see whether it has to be transplant or not. With regard to transplant, who is the donor? So donor condition has to see. So otherwise it will be in the
No order is in past, my lord.
Otherwise it will be market.
Yes, for that reason, statute is there, my lord.
Correct.
My lord, for that reason, my lord, there is the authorization committee. Thereafter, there is a provision of appeal.
That's why
if they order, my lord, kindly pardon me, my lord.
You have not gone through the report.
Yes, I gone through the report, my lord. My lord, there is 3 paragraphs.
Yes, you just a minute, petition. You tell me.
Yes, my lord.
What are the documents you have produced that is up to July 2025?
My lord,
After
kindly.
just a minute,
Yes.
July 2025, you hold the meeting on 11th November 2025. Why you have not taken the decision?
11th November 2025.
2025, a meeting was held.
Yes.
So 11th of November, and now you are relying upon this all the document that is of the July and August.
Yes.
Correct.
Yes.
So if you find that all these things is there, so why you have not directly rejected that application?
Kindly, my lord, takes the trouble. My lord, kindly takes the trouble of this is of August, and then my lord, kindly first, my lord, kindly takes my report. The last 2 part I am just placing.
5th and 6th.
The 5th and 6th. The verification committee, after careful examination of the case,
rejected that.
Found,
But
yes.
that's why. Then you read with. Then
Lord,
you read with that.
kindly, my lord, takes the memo of 12th March 2013, which is at the 2nd page of my report.
Where?
My lord, the 2nd page, annexure A. My lord, I apologize, my lord, for the bad
Yes.
quality of print.
Correct.
My lord, this is, my lord, the memo number HF/O/MERT/ such and such, dated 12th March 2013.
Correct.
My lord, this is issued by the Government of West Bengal, Department of Health and Family Welfare, MERT branch, Swasthya Bhavan. My lord, the memo is subject constitution of verification committee to assist the authorization committee under the Transplantation of Human Organs Act 1994. My lord, kindly sees, my lord, the state government has constituted an authorization committee. My lord,
Correct.
flips over to the
Now-
fourth
now you
line.
come
It
to
is
the-
laid
now-
down.
Now you come to the page 2.
My lord, I am at
Paragraph
page
F.
2, my lord.
Yeah.
Kindly, my lord, takes the
Paragraph
trouble
F.
of second paragraph, 4th line, my lord. Kindly takes. It is laid down. It starts from. It is laid down in section 9, subsection 3 of the Transplantation of Human Organs Act 1994 that this is quoted, my lord, 3. If any donor authorizes the removal of any of his human organs before his death under subsection 1 of the section 3 for transplantation into the body of such recipient, kindly notes, not being a near relative, as is specified by the donor.
So
by
the
reason
court
of-
is not on that.
Yes, my lord.
Court is that the donors have applied.
Yes.
Correct.
Yes.
Filed the affidavit and all these things, and
Yes.
you have called for the report.
Yes.
After calling for the report, you have conducted the meeting on 11th November.
Yes.
Correct. Kindly come your page. I am not
Yes,
going
yes,
to the
yes, madam.
repetition.
Yes, madam.
11th
Yes, madam.
November. Page 10.
11th November, yes.
Correct. Where is your finding? It is rejected or allowed? Where is the finding?
This is one provisional list of patients.
No, list
These are
of
the persons who are authorized.
My lord, kindly.
11th November.
Yes, my lord.
And you have verified and you are relying upon the report of the police authority. Kindly come to that is the report of
Yes, yes.
28
Police authority report.
August 25.
August
25.
28th August 25.
Then and 11/11/25 your meeting was held, and prior to that the SDO report is also there.
Yes, it is there.
So why you have not taken the decision? You take the decision.
And my lord, not only that, my lord, statute
We'll
is
take the
very.
decision and communicate.
My
If not already.
my
done, so I-
my lord, kindly
No,
take.
you have mentioned the rejected. Where is the rejection order?
My lord, what I am suggesting now, my lord, if already there is, if they have not taken a final decision and not communicated, my lord, they'll do so. If all not already done, my lord, kindly passes
My
that
lord,
order. We
two
will-
things, my lord. I before my lord, the express order, my lord. Kindly take, my lord, Rule 23 of 2014. My learned friend referring 2013 notification.
This is the
After
government-
that, my lord, Thereafter, my lord, rule came up, my lord. Kindly see, my lord, rule 23. Decision of authorization committee. 2014 rule. The authorization committee, which is applicable only for living organ or tissue donor, should state in writing its reason for rejecting or approving the application.
Where from you reading?
My lord, 23, 2014 rule.
Huh?
Which I handed over, my lord. 2014 rule, rule 23, my lord. Rule 23. May I read it, my lord?
In case the donor.
Decision of authorization committee. The authorization committee, which is applicable only for living organ or tissue donor, should state in writing its reason for rejecting or approving the application.
That's why I'm
Yes, the rule itself states they expressly they have to make this written rejection, and not only that, my lord. Thereafter, my lord, there is a provision of appeal under rule 33, my lord. In our state, my lord, till date, that appellate body is not yet constituted, my lord.
Different thing if appellate body is not constituted, the writ jurisdiction is here.
Yes, my lord.
Okay, I am
but the rule expressly says they ought to, my lord, expressly give the reason why they rejected, my lord. Orally,
we shall communicate.
The petitioner has filed the present writ application. Present writ application, praying for
just body naam
direction upon the respondent authorities, particularly Director of Medical Education and the Authorization Committee, Government of West Bengal, to consider the request of the petitioner for grant of approval for the renal transplantation of the petitioner who has been diagnosed with end-stage renal disease and is urgent need of kidney transplant. Counsel for the petitioner submit that the petitioner is suffering from where is the medical certificate?
Page number 27.
Is suffering from CKD stage 5 and the petitioner needs renal transplantation as the mode of treatment. Full stop. As per the advice of the doctor, the petitioner has arranged the donor. Who is the donor? What is the name?
Mithun Nag.
Donor, namely Mithun Nag, for
respondent number 7.
Mithun Nagu is the respondent number 7 for donation of the kidney to the petitioner. Full stop. Accordingly, the petitioner has applied for before the authorization committee for transplantation of the kidney of the petitioner by allowing the donor to donate the kidney of the respondent number 7 to the petitioner. Counsel for the petitioner submitted, though the name of the petitioner is appearing in the list prepared by the committee held on prepared by the organ transplantation board held on 11/11/2025, but till the authorities have not taken any decision by allowing for kidney transplantation. Then counsel for the respondent authorities have submitted the report wherein it reveals that 2 members verification committee has been constituted in order to support and assist the function of authorization committee with additional input and information under the Transplantation of Human Organ Act 1998. On receipt of the proposal of the petitioner for permission of renal transplantation of the petitioner, the 2 members verification committee submitted the report. After receipt of the verification report along with the police verification report, the case was placed before the board of the meeting of the state level authorization committee on 11/11/2025. In the report, it is mentioned that after careful examination of the case, it was found that PVR is totally unfavorable and there is a specific objection regarding involvement of financial transaction and middlemen. And so the case was rejected by the board meeting. Full stop. The petitioner has also disclosed the minutes of the board meeting and disclosed the notice of the board meeting which was scheduled to be held on 11/11/2025. And the respondents herein in the report have submitted the notice of the board, but have not disclosed the decision whether the request of the petitioner for transplantation of the kidney has been rejected. In view of the above, writ petition is disposed of by directing the authorization committee to pass a reasoned and speaking order as per the request made by the petitioner. If not passed, if any order is passed by the authorization committee, the said order be communicated to the petitioner within a period of 1 week from date. 1 week from date. 1 week from date.
Another thing, my lord, there is a specific in the statute, my lord, there is a specific restriction section, my lord. Section 9 speaks about the restriction. The only restriction in this organ transplantation is the mental health.
Let the rejection report you challenge.
Yes, but until and unless they handed over to me.
That's why I directed. If not, then they will.
If not, as I, my lord, two things, my lord.
I made
Instead
the
of 1 week,
in this regard, my lord. There is no such communication on the from the.
I recorded no communication. That's why take decision. If not taken, if taken, the communication made communication within a week.
One
from
prayer, my lord, instead of 1 week makes it 2 weeks because
No,
my lord, of
this
the
is-
election is.
No, there is this is a
What
live
doctor
play.
will do?
This is live play.
And my lord, let them communicate the order then directly to the authorities also. We will also do it.
That's
But
it.
let them also directly communicate.
Who?
The petitioners. Let them a direction, my lord, then let them communicate it immediately. We will do from our end, but let them also, my lord, kindly do it.
Okay.
But kindly records that.
The petition is directed to communicate this order to the authority for compliance.
Grateful to you, lord.
My lord, then my lord, thank you. This is what I would like to do.
Yes, today you will
But
get the
okay,
order.
he is in last stage, my lord, stage 5.
Today you will get the order. Today you will get the order. Call the list. Call the list.
My lord, ABD does have it, my lord.
Your Lordship, 17 was the
Item number 17.
Your Lordship, may I hand over the copy of the report?
Grateful.
এই আমার ফোনটা কোথায় রাখলাম? পেয়েছিস?
Yes.
তার এদিকে চলে আসো। ওদিকে যেতে পারবো না, পিটিশনার পিটিশনার পাশে চলে যাবো।
अरे लेके इसका है आप लोग क्यों कंफ्यूज होते हैं?
हाँ, दादा।
Yes.
We had argued the matter extensively, but your lordship wanted the report.
Yes, you got the report.
Yes. Lord, kindly see the report. I'm just specifying the paragraph 6. It is further submitted that during the filing of the nomination, the affidavit of Subhuti Auditing Munshi was initially uploaded by the technical team. Subsequently, certain defects were pointed out. Following which, the candidate corrected the affidavit. The corrected affidavit was uploaded in the such portal, and the defective affidavit was deleted from the system. The entire scrutiny, entire process of scrutiny was conducted in presence of the honorable observer and was duly recorded through video. Kindly consider two things. Who is filing the report? The filing the report is not returning officer. My entire case is not paragraph 12 onwards on these things. So the returning officer will not have acted in a bias. So far as this deletion part is concerned, I just refer to one clause. Kindly comes kindly takes page 41. Whether your lordship comes to page 42.
Yes.
Page 42 5.20.3. It says
uploading affidavits by the candidates on website. The affidavits filed by the candidate, whether set up by the recognized political parties or recognized political parties or independent, shall be put on the website soon after the candidate files the same within 24 hours. In any event, even if the candidate withdraws his candidature, the affidavit already uploaded on the website shall not be removed. Next, in case where the columns are left in the blank in the affidavit, a notice is issued by the returning officer for filing a fresh and complete affidavit. The incomplete affidavit may also be uploaded on the website with a note indicating the affidavit is incomplete and the candidate has been issued notice, and if and when the candidate files affidavit subsequently, the same should also be uploaded on the website immediately on the same day. Next, we have 5.20.4. The uploading counter affidavits on the website. The affidavit filed by the candidate are to be disseminated in the displaying copies thereof on the notice board of the returning officer by making the copies available freely to those seeking the same. In the same order, it was stated that if anyone furnishes information concerning the statements made by any candidate in his affidavit by means of a duly sworn affidavit, such counter affidavit shall be disseminated along with the secretary of the candidate concerned. In the same manner, that is, displaying the copy on the notice board and the furnishing the copy on the board on others on demand. The Commission has decided that all counter affidavits duly notarized filed by any person against the statement in the affidavit filed by the candidate shall also be uploaded on the website along with the affidavit concerned, and such uploading should be made within 24 hours of the filing of the same. Because there is no provision for deleting any affidavit. Well, how the returning officer has done it? Well, I am asking the person.
But Mr. Tiwari, this is what the court.
I am not on that. I have a specific grievance against the returning officer. Well, kindly direct the Election Commission of India to take necessary steps against the returning officer. Number one. Second point, I have a
See, Mr. Tiwari, problem is that now election process is started.
Absolutely.
Correct. Now, with regard to this is the nomination paper. The candidate, whoever the candidate, his nomination as per your version, the nomination paper was not correct, but the returning officer accepted that. Now he has taken the plea that the affidavit he has changed and he has admitted that. Whether it is correct or not, that you have to challenge. If suppose if the petitioner, the private respondent won the election, then it is a question of election petition.
My entire case is based on paragraph 2.
Correct.
And my case is this: the returning officer has proceeded in a biased
Correct.
manner. And if the returning officer is proceeding in a biased manner, then 226 code is not all.
No, I am not telling. Then if you are telling, then in that case, then I am passing an order for affidavit. Let the file affidavit. It will decide on the merit.
So kindly, I want.
No, interim order can be passed.
One line observation will be sufficient. Kindly consider. Today, his conduct is apparent from the pleading itself, and his conduct is also apparent from this report itself. This report, he is saying that he has deleted the affidavit.
Correct. Correct. That's why I am telling. That's why.
Against whom I have made an allegation. That person is submitting a report.
Correct. In that case, let the all authority file affidavit. It will be decided.
I have one submission.
Kindly consider one thing, in that case, one liner, I am just submitting your lordship, the conduct of the returning officer is apparent from the records itself. Entire election, he will be conducting the entire election. Kindly consider this fact. If the umpire is biased from the very beginning, then what will be the result of the match?
It is not your case for the changing of the returning officer.
Subsequently, it appears, kindly see what I have prayed.
So in the prima facie case, how the court can record anything against the officer unless and until it is to be decided on merit.
Let the returning officer file an affidavit to the referee.
Correct. That's what I'm telling. Let the file affidavit in opposition. Let the court decide on merit.
Let the returning officer file a short affidavit. Kindly give him 2-3 days. Let him.
How during election period? How it is possible, Mr. Tiwari?
This is returning officer. 10 kilometers away.
Maybe.
This factor. Only a short affidavit. Let him explain. The way he is proceeding with the election, this is absolutely contrary to the democracy itself.
I have got two submissions. Article 329 of the Constitution is clear and assuming that in case of the Mahendra Singh Gill's case interpretation and subsequent judgments, that is specifically related to an allegation in malpractice and other things of the election and thereafter. Here is a case of exercising jurisdictional duty under the statute. Page 53 clearly provides objections and summary inquiry, reasons to be recorded in every case of objection or rejection. If it is not done, and if it is non-exercise of the jurisdiction which is vested to him on the statute, the writ court is not powerless. That is well settled in the power of judicial review.
Yeah, that's I'm telling.
That is, secondly, if your lordship does not want to interfere now by passing an interim order, election to this constituency is scheduled on 29th, not tomorrow. This constituency. So therefore, what he has submitted, I don't know whether your lordship would direct. Question is, question of exercising jurisdiction. This man, the returning officer, has to file a personal affidavit. Why did he not exercise his jurisdiction vested upon him under the Representation of People's Act? That is my submission.
Only one thing. In the entire report, you will also find that there is no discussion about what is the fate of my counter affidavit. Whether he has passed any order or not, nothing only reflects. He said that he had not passed any order out of itself.
Suppose today also can this court pass an order for if suppose we call the affidavits and whether this court at this stage in the mid of the election can change the returning officer.
So, one line of observation will be sufficient. I am not saying your lordship will direct the ECI to take necessary steps. Nothing more, nothing less.
Yes.
ECI should take.
Your lordship, in terms of the statute, we are required to, the returning officer is required to give a reasoned order. In this particular case, he did not. The first affidavit which has come up is this. Your lordship could, for disposing of his grievances, your lordship, instead of, if there is a direction for affidavit, he will be prevented from filing election petition, if so required.
Naturally.
If it is, this matter is pending.
That's why if the court will continue with that, then the election petition go.
Same issue cannot.
No, that is not subject to the election to the candidate, subject to the decision of the writ court.
Yes.
Can I discuss for only one thing? And this is the report one. This is the report, paragraph 2. Audit. The complainant was present during the proceedings and latter expressed satisfaction and left the nomination route. If that is the finding, it is very easy for the learned counsel representing the returning officer to attack his own order by saying it is unreasoned order. I do not know whether such an action in a writ proceeding is permissible. Whether a respondent to a writ petition can attack its own action. In the teeth of this finding, insofar as I am concerned, paragraph 4, I am representing Torun Tiwari. During scrutiny of nomination, the complainant was asked to provide documentary evidence in support of his objection. However, he failed to do so. No defect of substantial nature was found in the nomination paper, and accordingly, the nomination was accepted. The candidate was not present at the time of scrutiny. Pausing here for a moment, if he is unable to satisfy and justify his complaint, with greatest of respect, that little that we have learned from your lordship, perhaps not reason in support of what? Had there been something before him, contra, then and in the teeth of this finding, insofar as Mr. Kaur's client is concerned, I don't think the writ petition should travel any further in the light of the provisions enumerated in one of the provisions which says an election petition is the only answer. These are my submissions.
Just one thing, I don't know short.
Just a minute. Very short. Very short.
Look, today, your lordship's writ petition is for a particular purpose. Your lordships kindly sees the prayers in the writ petition. The prayers plot starts at page 20.
Yes.
Kindly see B. He wants entire records to be produced and the objection, counter affidavit, note sheets, etc. and all connected records. And C,
commanding respondent authorities forthwith preserve and produce all digital electronic records relating to the affidavits of the respondent number 10, including upload history made such and such and all back portal. Issue a writ of certiorari commanding to certify transmit records. Mandamus commanding respondent number 7 to lawfully consider and dispose of the petitioner's objection. Counter affidavit strictly in accordance with section 36 of the Representation of the People Act. Now, Lord, these are the prayers made in the writ petition. Lord, my submission was based on section 100, section 36 and section 100 of the Representation of People Act. If your lordships kindly take section 36 first. Lord, kindly see section 36(4). I had placed section 36 in entirety. I don't want to place it. Kindly have a look at section 36(4). It says, returning officer shall not reject any nomination paper on the ground of any defect which is not of a substantial character. If you remember, if your lordship remembers, his grievance is that first the signature was not there. Second, the signature was there, but a wrong date was put so far as the notarial attestation is concerned. Lord, subsection 4 of 36 says that, Lord, if there are curable defects, this clearly, Lord, specifies that only the substantial character. And what is substantial character? There is a judgment. I'll place reliance on that. But, Lord, this is what it is. Now come to 100. Kindly, my Lord, come to 100 straight away. Kindly take section 101(c) first. Yes. That any nomination has been improperly rejected. This is one. Now come to D. That the result of the election insofar as it concerns a returned candidate has been materially affected, one, by improper acceptance of any nomination. Correct. So, Lord, in both cases, even if it is an improper acceptance of nomination paper, the remedy provided under the Representation of People Act is by an election petition. Because 100 starts, it says subject to the provision subsection 2, High Court is opinion, etc. And it says that the corrupt practice, etc. These are the grounds on which declaration of an election to be void. Section 100, kindly see the opening words of section 100.
Subject of provisions.
Yes. And it says ground for declaring election to be void. Yes. So, Lord, on both cases, even if it is a rejection or even if it is an acceptance of nomination paper, both cases, Lord, statute provides that it has to be by way of an election petition. Now, Lord, your lordships may kindly, your lordships have seen the report. The report clearly says that the only objection raised was discussed and decided in the presence of the candidates. Kindly come to paragraph 2. Yes. During scrutiny of the nomination paper of Aditi Munshi, her election agent, Devraj Chakraborty appeared around 1:30 p.m. He was requested to submit an explanation regarding the nature of complaint. Subsequently, an affidavit duly notarized on 7th April was submitted on behalf of the candidate. The complainant was present during the proceedings and later expressed satisfaction and left the nomination book. And it says with regard to the other complaint, this is not the complaint against Mr. Bhattacharya's client. Then Lord 4, during scrutiny of nomination paper, Tarun Kumar Tiwari, the complainant was asked to provide documentary evidence in support of his objection. This is regarding his objection. Then 5, the scrutiny proceedings were conducted in accordance with the provisions of the Representation People Act and the Returning Officer's Handbook, para 6.10, which stipulate that nomination should not be rejected solely on the ground of defective affidavit, provided that prescribed affidavit has been filed. And then it is further submitted that during the filing of nomination affidavit, Srimati Aditi Munshi was initially uploaded by the technical team. Subsequently, certain defects were pointed out, following which the candidate corrected the affidavit. Now, Lord, kindly have a look at the affidavit once. What was the basic defect in the affidavit? Your lordships may kindly, yes, kindly, Lord, come
but,
to.
But what is your answer to the page 42?
Page
5.20.3?
Page 42.
Yes, of the writ petition. Rule 5.20.23 to 20.24.
5.20.
Yes, 5.20.3. Yes.
Yes. Now, Lord, assuming something has been done wrongly, Lord, whether this is the forum to decide at this stage of the election, supposing, Lord, the returning officer has done something wrongly, which he is not supposed to do. But this is not the time to decide this issue, Lord, in an application under Article 226.
Okay.
And I tell your Lordship, kindly, Lord, have the latest judgment, Lord, on this. This is reported in 2026, Volume 3, SCC. I have already, Lord, relied upon 78.1 SCC.
Yes.
373.
You are for the respondent number 7.
I am for 9. Sorry, I am for 10. Basically.
Yeah, paragraph.
Lord, first, Lord, come to paragraph 11. Kindly see, Lord, what are the issues before.
Why the during election you are not making this resolution? One election court is to be determined.
Sure. It should. Lord, kindly see 11.1. Firstly, whether the non-mentioning of the income shown in the income tax return for 4 financial years in the Form 26 affidavit and its portrayal in nil would amount to non-disclosure, thereby rendering the acceptance of the nomination of the respondent number 1 improper and making her election liable to be declared void under section 101B. Lord, nomination paper which was filed did not contain, Lord, the income for the last 4 years. Okay. And with that nomination was wrongly accepted. Now, Lord, this was challenged in an election petition. Your Lordships may kindly come to paragraph 44.9. Yes. 44.9 and 45, they discussed, Lord, whether section 100 is applicable in the facts of the case. Kindly, Lord, come to 45.3. As regards the other ground concerning improper acceptance or rejection of nominations, has your Lordship got that? Or the non-compliance with the provisions of the Constitution or the Act or the rules or orders made under the Act, it is observed that these issues are mainly technical and involve some element of subjectivity, since no nomination paper can be rejected for a defect that is not a substantial character as provided under section 36(4) of the Act. Then, Lord, please come to paragraph 52. For, Lord, no income was disclosed in the nomination paper, which the candidate is bound to disclose. So kindly see how the court looks at it. Kindly see paragraph 52. This issue relating to disclosure of information may be viewed from another perspective. There is a provision under the statute to prove the nomination of a candidate before election is held and result is declared. That is during the scrutiny of the returning officer, who can reject it at the nomination stage if there has been a failure to disclose necessary information by the candidate. This exercise of examination, the validity of the nomination can also be undertaken by the court after the election is over. In an election petition, and result is known to the voters, as in the present case. This post-election judicial scrutiny about any such irregularity or deficiency in not disclosing necessary information serves as a safeguard against arbitrary action by the returning officer or any injustice caused to a candidate. This is exactly the case that my learned friend is trying to make out before your Lordship. Then, Lord, kindly see paragraph 55. Nevertheless, there is a qualitative difference between these two stages in examining the issue of non-disclosure of information. At the time the returning officer scrutinizes the nomination paper of the candidate, the voters are yet to express their mind through the ballot box. However, once the election is concluded and the voters have delivered their verdict and the same has been made public, a new dimension is introduced, that is the people's mandate, which cannot be overlooked by the court when examining the legality of the acceptance of the nomination. Then, Lord, kindly take paragraph 54 that deals with, Lord, how the court should proceed post-election with regard to the nomination, acceptance of nomination paper. Kindly come to paragraph 55. In a democracy, the will of the people expressed through election is a sacrosanct. which in Latin is conveyed by so and so, signifying the voice of the people and collective wisdom should be respected, etc. Then under the circumstances, paragraph 57, once the people have spoken their mind in casting their votes through the ballot box, responded their confidence in the candidate, whenever the issue of invalidating the people's mandate is raised before a court, the court must be very careful and circumspect.
That is after election.
Then kindly see paragraph 58, kindly take placitum B. The court, therefore, as your lordship seen that, must keep in mind that declaring an election void solely on the ground of non-disclosure of assets, if it lacks substantiality, would undermine the validity of the popular mandate and nullify the choice, etc. Ultimately, my lord, kindly come to paragraph 61. Minor procedural errors, as your lordship said, or purely technical objections of inconsequential nature, thus should not be allowed or to override the mandate of the electorate. Courts must be careful not to become tools that undermine the popular mandate in the name of technical perfection. The will of the people expressed through the election result should be respected. A judicial victory based on technicalities rather than electoral victory won in the electoral battlefield should be avoided unless the mandate and the integrity of the electoral process are compromised by fraud or corrupt practice. Statutory provisions, judicial approach in election law have all been shaped by this cautious approach. But in fact, kindly come to page paragraph. Yes, come to paragraph 61 once. Which also says that minor procedural errors or purely technical objections of inconsequential nature. Paragraph 61.
Yes.
That is, Lord, this is reiterated.
That you already.
Yes. And then, Lord, kindly come to conclusion at 1-1.
Yes.
110 plot it starts. Kindly plot take 112. That will suffice. In the light of the legal position exposited, on examination of the facts in the peculiar background of the case, we hold that the non-disclosure of income is the income tax return for the 4 financial years by respondent number 1 is not a defect of substantial character. Therefore, the nomination could not have been rejected under of the representation of the as contained by the affidavit, etc. Now, my lord, here, kindly, my lord, have a look at the affidavit. What is the substantial defect in the affidavit? Kindly, my lord, first take the affidavit at page 126.
Yeah.
126, my lord, is the petition. Kindly take the petition.
126.
126, it starts. Kindly come to page 144. What is the defect here?
140.
Sorry, 141. 140.
Yes.
My mistake.
Signature.
There is no signature. Right? And Lord, the date, instead of 7, it is written as 8. Now, Lord, kindly come to the second affidavit, which was uploaded by deleting the first one, 126.
Yes.
Lord, here,
No, 126.
126 it starts.
It continue 141.
Oh, sorry, my mistake. It 120. I should have shown your lordship 125. Page 125.
125, the earlier one.
The earlier. This is the second affidavit,
correct,
which is Lord sequentially it has come first, and the first one.
So 126 is the first affidavit.
First, 126 to 141.
Yes.
141, the signature was lacking.
Yes.
But there was a signature by the side.
Yes.
It was not a proper signature. So, Lord, this signature was corrected at page 125. Your lordships will find the second affidavit corrected the signature. That's all. And Lord, there was a discrepancy on the question of date, because 7th, your lordships will find on the left hand side, your lordships will find this affirmation was done on the 7th, and this is written on 8th. Therefore, Lord, an affidavit.
You have given the affidavit.
I have given the affidavit that saying that it was affirmed on the 7th, but by mistake the date 8 occurred.
That's all.
And the officer concerned, the returning officer, was fully satisfied with regard to that. And Lord, your lordships will find that it is recorded that the complaint has left, but let us not get into it. Let us not consider a situation where, Lord, it is the objections were improperly rejected. Lord, even then, I say that these objections are absolutely not substantial.
Okay.
And could not have been, Lord, a ground for filing the writ petition. And in any event, Lord, writ petition is not maintainable when the statute provides that it can only be by an election petition. These are my thoughts.
Okay. Who is the petitioner?
The petitioner, Lord,
independent candidate.
Independent candidate.
Independent candidate. I represent, Lord, a candidate who has been nominated by the All India Trinamool Congress.
I am also an independent candidate.
You are for the 10.
I am for 10.
And 11 is the independent.
Yes, another independent candidate was
Tarun Kumar Tiwari. Not Mr. Tiwari.
Tarun Jyoti.
Tarun Jyoti.
for the BJP.
The purpose is the same mistake which your lordship made just now.
That's right.
Now, your lordship will straight away comes to page 54 once.
50?
Page 54.
Yes. Grounds for rejection.
Yes.
610.
Yes. Now, prior to that, Milord, your lordship, Milord, kindly take Milord. Kindly take Milord 6.9, page 53. It says, Milord, insufficient grounds for rejection of nomination papers. Now, Milord, kindly turn, Milord. Next, Milord, page 54, 6.10. The grounds for rejection of nomination papers.
Six point?
6.10.
Yes.
Page 54.
Yes.
It says, Milord, grounds for rejection of nomination papers. The returning officer must reject a nomination papers if a candidate is clearly not qualified in law to be the member of the legislative concern. Well, I'm skipping next one also. Next, Milord, number 3, requirement of section 33 of the RP Act 1951 are not fulfilled. Next, Milord, 4, the prescribed affidavit has not been filed by the candidate.
By at all.
By at all. Now, Milord, note is there. If the prescribed affidavit has been filed but are alleged or found to be containing false information, the nomination, next, Milord. 5. The nomination paper has not been signed by the candidate or by required number of his proposers. The proper deposits, no one on this. Now, Milord, so far as Milord, this 4 is concerned, the prescribed affidavit has not been filed at all by the candidate. Now, Milord, here in this case, Milord, what happened, Milord? First affidavit without signature. Admitted fact. Second affidavit, Milord, signed on 8th, affirmed on 7th. Now, Milord, admitted fact. Now, Milord, I am not going into all these things. I am not going to merit. I am not here, Milord, to cancel his nomination. What I am, Milord, today as on date, Milord, I just want, Milord, kindly dispose of my writ petition, Milord. One liner observation. The returning officer conduct is not in consonance with this election rules. And Milord, not only that, Milord, kindly, I just want to point out two pages, Milord. Kindly turns, Milord, page 156 once. 156. It starts at page 155, 155.
Yes.
Now, Milord, you'll also find this is the nomination paper filed by somebody. 155.
Correct.
Now, Milord, next page 156. You'll also find.
Why you are dealing with this?
Milord, I cannot name that lady, Milord. Milord, kindly down, Milord, page 156 once.
Yes.
Milord, so far as 156 is concerned, Milord, you'll also find that affidavit uploaded. Correct. Thereafter, Milord, counter affidavit that was also uploaded. Another counter affidavit that was also uploaded.
Correct.
All these things were uploaded of this heavyweight candidate. But all these affidavit, counter affidavit of this heavyweight candidate was uploaded. Now, Milord, kindly see, Milord, so far
because they have taken the precautions.
They have taken the precaution.
Well, so far as I think this
Heavyweight
these
can-
R10.
Heavyweight candidate of all the parties for the heavyweight candidate, they take the precautions.
I think the R10 is more heavyweight than the page 156. Yes, I have reasons. Now kindly have a look, page 158 once. 158.
Not only the candidates, Lord, themselves are well seasoned, but Lord, they have advisors who are also well seasoned, because everything is scrutinized by the people who are around.
Yes.
Page 158. Page 158. 158.
Yes.
Now kindly see, Lord, this is R10.
Correct.
Now next page 159. 159.
Yes.
Now your lordship will find only R10 evidence has been uploaded. There are two counters. My learned senior friend has said, subsequent affidavits were filed, but even after two affidavits were filed, another affidavit was filed. All these affidavits ought to have been uploaded. Till now, the election commission is showing only one affidavit is there, and not even my counter objection has been uploaded till now. So, why this biased attitude by a concerned officer? I am putting one question to him, his conduct also.
Yes.
Only one thing, election commission to take appropriate steps. Nothing more, nothing less. Let the election commission take appropriate steps.
There is no pleading of bias in.
My learned friend is not representing the returning officer. He is not representing. Yes, pleading is there. Paragraph 12. There is a specific pleading.
Bias has to be pleaded.
My learned friend, he is not representing the returning officer. Paragraph 12, specific pleading is there.
Yes.
And all elected records should be preserved. That is prayer C, page 21. Page
For
20.
what? If the writ petition disposed of, why the preservation?
Your lordship, can you direct them to preserve all these things? This otherwise, what happened?
That's why I'm telling. If you want, then I will decide on affidavit by preserving or whatever it is. So
Even if on disposal,
how the preservation order can be
As per the
passed?
latest notification, I'm not carrying it. 7 days from date of result, aggrieved party has to approach under election petition to challenge the.
The election petition automatically.
But the date is
That our rules provide. That's the election rules. Election petition rules provide.
My lord, let it not be converted. Any order taken, not doing. Not scold.
So it will be converted as an election suit, and the court will be taken as a court. The grievance of the petitioner in the present writ application that the private respondent number 10 has submitted an affidavit along with a nomination, and when the petitioner, being an independent candidate, found that the private respondent number 10 has not filed the affidavit in accordance with law. Accordingly, the petitioner has filed the counter objection by way of an affidavit. By way of an affidavit. By alleging that where is your counter affidavit? What is allegation?
Page 59.
Page 59, 60, yes. Alleging that
there are two counter affidavits, one in respect of R10, page 59,
yes,
and R11, page 84.
yes, alleging that in the affidavit, portion, there is no signature of the respondent number 1, and in the affidavit it is mentioned, the date is mentioned 8th April 2026, but the seal of the notary public, in the seal of the notary public, the date is appearing at 7th April 2026.
it is the further contention of the petitioner that with regard to the other candidates, comma, the returning officer already uploaded the affidavit and counter affidavits time to time received from the candidates. But in the case of the private respondent number 10, only the affidavit affirmed, only one affidavit was uploaded on 9th April 2026. Thereafter, neither the further affidavit, neither the counter affidavit of the petitioner, but affidavit of the respondent number 1 uploaded on 9th April 2026, but the counter affidavit filed by the petitioner raising objection on the affidavit of the private respondent number 10 was not uploaded. Was not uploaded. The petitioner has relied upon clause 6.6 of the, what is this notification?
Handbook of Returning Officer 2023. Handbook for
6.6 of the handbook of the returning officer, and submits that even if any objection is raised, comma, returning officer shall have to hold a summary inquiry and to decide the same and to treat the nomination paper to be either valid or invalid. But in the present case, though the petitioner has filed the counter affidavit raising objection of the affidavit by pointing out the discrepancies in the affidavit of the respondent number 10, but the returning officer has not passed any reason order either by accepting the same or declaring the same or rejecting the affidavit. Even the returning officer has not rejected the counter affidavit filed by the petitioner. The petitioner has further relied upon clause 5.20.23 and 5.20.24 and submits that in the said clause, the uploading of affidavit filed by the candidates and uploading of counter affidavits is to be uploaded on the website. But in the present case, the returning officer has violated the provisions of clause 5.20.3 and 5.20.4 by not uploading the counter affidavit filed by the petitioner. Full stop.
By not uploading and by deleting, not
uploading and deleting, the affidavit filed by uploading the counter affidavit filed by the petitioner and deleting the affidavit filed by the private respondent number 10. Private respondent number 10. Full stop. The petitioner has relied upon petitioner has further relied upon clause 6.10 of the handbook of the returning officer and submits that under the said provision, it has been categorically mentioned that the returning officer must reject the nomination paper if the nomination paper has not been signed by the candidate or by the required number of the proposal. Full stop. Any further? These are the full stop. Learned Counsel appearing for the petitioner has relied upon the judgment in the case of Resurgens, Resurgens, India versus Election Commission of India and another, reported in 2014, volume 14, SCC 189, and submits that 189 and submits that
It is the duty of the returning officer to check whether the information required is fully furnished at the time of filing of the affidavit with the nomination paper, since such information is very vital for giving effect to the right to know of the citizens. Full stop. In the present, full stop. If by relying upon the said judgment, comma, the petitioner submits that in the present case, the affidavit filed by the petition itself has not been signed by the petition, and thus it cannot be said that the affidavit filed by the private respondent number 10 is an affidavit in accordance with it. Full stop. Per contra, an advocate appearing for the state authorities has submitted report and submits that
Your Lordship, ECI.
you are ECI, not other state, because
We are
as
all under ECI.
okay, ECI appearing for the ECI has submitted report and submits that during the scrutiny of the nomination paper of the private respondent number 10, comma, her election agent had appeared and requested to submit an explanation regarding the nature of the complaint. The complainant was present during the proceeding and later he expressed his satisfaction and left the nomination room. An advocate appearing for the election commissioner submits that it is admitted that the the returning officer has not passed any reasoned order, though he has accepted the affidavit filed by the private respondent number 10. Full stop. Learned counsel appearing for the respondent number 10 submits that initially the petitioner, the private respondent number 10 has filed affidavit, but the said affidavit does not contain the signature, and when the private respondent number 10 came to know that no signature is available in the affidavit, immediately the petitioner has filed another affidavit, and the returning officer, by deleting the first affidavit, has accepted the second affidavit which bears the signature of the respondent number 10. He further submits that the full stop. He further submits that as regard the date mentioning in the affidavit, he further submitted with regard to the date appearing in the affidavit, the private respondent number 10 has submitted an affidavit before the returning officer by affirming that she has executed an affidavit on 7th April 2026 before the notary public at the residence of the notary public. And as such, the returning officer accepted the affidavit filed by the private respondent number 10 by dating the date of affirmation on 7th of April 2026. Full stop. Learned counsel for the respondent number 10 further submits that as per clause 6.6 of the handbook of the returning officer, it is provided that the returning officer's decision could be challenged later in an independent petition, and hence the importance of recording a brief statement of reasons at this time. If the returning officer accepts the nomination of a candidate overruling the objection raised by an objector, he may supply it with the certified copy of his decision upon his request. But in the present case, the petitioner has not made any request to the returning officer for supply of the reason for rejecting the counter affidavit filed by the petitioner. Full stop. He further submits that the petitioner has challenged the affidavit of the private respondent which cannot be challenged in the writ jurisdiction. It is the subject matter of the election petition. The petitioner could have challenged the same after the declaration of the election, not in the present writ application. Learned counsel appearing for the private respondent has relied upon the judgment in the case of Ajmera Shyam versus Koya Lakshmi and others, reported in 2026, volume 3, SCC 373, and submits that
বাস 3 লাইনের একটা কথা থেকে দেবো ও 1 মিনিটে যত ওয়ার্ড ওর অরিন্দম মুখার্জি ততক্ষণ ভাবে
non-disclosure of the income in the income tax return for 4 years financial years by the respondent is not defect the substantial character. Therefore, the nomination could not have been rejected under section 36(2) of the Representation of the People Act. Learned counsel for the respondent number 10 has relied upon section 36 of the Representation of the People's Act and submits that as per the said provision, comma, if the return officer shall reject any of the nomination paper on any of the defect which is not substantial in character. But in the present case, the returning officer did not find any substantial character, and thus the objection raised by the petitioner has rejected, and the affidavit filed by the petitioner has been accepted. Respondent number 10 has been accepted. He further relied upon section 10 of the Representation of the People's Act and submits that as per section 100 of the Representation of the People's Act, if the improper acceptance of the nomination by the returning officer is the ground for declaring the election to be void, and that is to be challenged in the election petition, not by way of a writ application. He further relied upon the judgment Mahendra Singh Gill and another versus Chief Election Commissioner and others, reported in 1978, volume 1, SCC 405, and submits that
প্রেজেন্ট করে না অর্ডার পাবে না পরে সেটা যেটা আটকেছে সেটা খুলে গেছে অর্ডার পাবে না চটকি পাঁচা লাঠি
no legislative enterprise in the High Court or the other court should be allowed to hold up ongoing electoral process because the parliamentary representative of the constituency should be chosen promptly. He submits that Article 329 of the Constitution of India covers the electoral matters, and as per the provisions of section Article 329B of the Constitution of India, writ petition is not maintainable once the election process is started. Yes, Mr. What is your submission? Mr. You are appearing for 11. Mr. Bandyopadhyay, learned advocate, appearing for the respondent number 11, has adopted the submission made by Mr. Kaur, who is appearing for the respondent number 10.
Apart from that, in the order, which has been produced today in paragraph 4, it is.
What is the order?
It was satisfied.
Report.
Today's report.
And he submits that the report submitted by the Election Commission of India reflects that the petitioner was present during the proceeding and he expressed his satisfaction, and thereafter he left the nomination room. Thus, subsequently, the petitioner cannot challenge the act of the the returning officer by making an allegation that the returning officer has illegally accepted the nomination form of the respondent number.
The writ petition, the lordship says that he has said that he was present
Full stop.
and he has not disclosed anything beyond that.
Full stop. He further submitted that in the writ application also the the petitioner has admitted that he was present in the nomination form, but he has not until the scrutiny of the nomination form. Full stop. Had the learned counsel for the respective parties peruse the materials on record. This could find that the only objection raised by the petitioner in the present application that the returning officer has accepted the affidavit submitted by the private respondent number 10, though in the affidavit there is no signature. And the date mentioned in the affidavit is 8, but the notary public and the seal and signature of the notary public provides the date of 7th April 2026. He further submit that full stop 2026. This could find that the returning officer and this court find that initially the private respondent has filed the affidavit wherein there is no signature is appear. There is no signature there is no signature on the verification portion. But in the horizontal portion, the petitioner has signed the said affidavit. But the respondent number 10 is not taking the benefit of the said signature. The respondent number 10 has admitted that when the respondent number 10 came to know that there is no signature in the verification portion, immediately the petitioner and the respondent number 10 has affirmed a further affidavit having the full signature of the private respondent number 10, and the same was accepted by the returning officer and deleted the first affidavit. Now, it is impossible for the said contention of the private respondent number 10 as the petitioner has disclosed the website document wherein the affidavit and the documents of the candidates have been uploaded. In the said uploaded website form, it is found that one affidavit was of the private respondent number 10 was uploaded on 9th of April 2026 at 12:32:42. Thereafter, there is nothing whether the objection raised by the petitioner was uploaded in the website or the second affidavit which the petitioner is now relying, the respondent number 10 is now relying upon, the respondent number 10 has filed the affidavit subsequently and deleted. The deleted portion is not available in the website of the private respondent of the ECI website of the ECI. Full stop. It is also admitted by the ECI that though the objection raised by the petitioner was rejected, but there is no reason order is passed by the returning officer.
Returning officer because
By the returning officer.
because the superior authorities might take action against.
Full stop. By the returning officer. It is true. Full stop. Section 36 of the Representation of the People's Act 1951 provides the scrutiny of the nomination. nomination. Section 32, subclause 2, subsection 2, within bracket C, provides that the signature of the candidate or the proposer of the nomination paper is not genuine, then it is to be rejected by the returning officer. In the present case, there are two documents. This court cannot decide whether the first was deleted and the second was accepted. As the returning officer has not as the report submitted by the returning officer has also not disclosed that he has deleted the first affidavit and where is that?
Highly similar page, paragraph 6. Second page.
Uploaded technically.
The corrected affidavit was uploaded in the such and such, and defective affidavit was deleted from the system.
In the report submitted by the returning officer, it is mentioned that during the filing of the nomination, the affidavit of the private respondent number 110 initially uploaded by the technical team. Subsequently, certain defects were pointed out. Following which the candidate corrected the affidavit. The corrected affidavit was uploaded in the Encore portal and the effective affidavit was deleted from the system. Full stop. This is to be decided only during the trial, not by in the writ court in the writ jurisdiction. Full stop. Section 100 of the representative of the People's Representation of the People's Act also provide that the improper acceptance of the nomination is the ground for declaring the election to be void. Considering the above, full stop. Considering the above, full stop. In the case of Ajmer Shyam Supra, comma, the Honorable Supreme Court has held that
Paragraph 61, 112.
held that minor procedural errors or purely technical objections of the inconsequential nature should not be allowed to override the mandate of the electorate. Court must be careful not to become a tools of undermine the popular mandate in the name of the technical perfection. The will of the peoples expressed through the election result should be respected unless it has been corrupted by the fraudulent practice, in which the case of the court should the court should intervene without hesitation. Full stop. A judiciary victory based on the technicalities rather than the electoral victory on the electrical battlefield should be avoided unless the mandate and the integrity of the electoral process are compromised by fraud or corrupt practice. Full stop. In the present case, the question whether the affidavit submitted by the respondent number 10 is valid or not. The petitioner has taken the stand that this affidavit is without the signature, and the date is also and the date mentioned is 8, but the notary public the seal of the notary public reflects the date of 7th of April 2020. The petitioner has taken the stand that petitioner and the returning officer have taken the stand that the affidavit has subsequently changed. Whether the changing of the affidavit subsequently is permissible or not is also the matter is to be decided only at the time of evidence. Thus, this court finds that in sitting in the writ jurisdiction, it is not possible for this court to decide whether the affidavit accepted by the returning officer is valid or not. Accordingly, the writ petition is disposed of by giving a liberty to the petitioner. If any occasion arises, the petitioner can raise all the points before the appropriate court at the appropriate stage.
Kindly make it, your lordship has not gone into the merit of this.
However, it is made clear that this court has not gone into the merit of the case. If the petition will raise any point before the appropriate court at the appropriate stage, it is open to the appropriate court oblique forum to decide in its own merit.
Only one thing, Milord. Let the ECI also should take decision, Milord, on the basis of my representation, which I have already submitted.
Your Lordship, ECI would take action against the.
Can you record that also?
Not, it may not be
Milord,
recorded.
ECI, Milord, only
will
one
take
thing, Milord,
steps.
so far as deletion party is concerned, this is contrary to.
This court didn't want to enter all this facts. Let you check. It is.
ECI is taking absolutely impartial stand. That's why Art 10, Art 11 are
But
there.
such a. You the Yes.
But I had your item number 21, my lord, I had mentioned. If your lordship kindly takes it up, my lord.
Matter, my lord, I'm
What is
leading.
the matter?
My lord, I'm leading. Yesterday, my lordship, my lord, granted me, my lord, leave. Not much, my lord. I will take only 10 minutes time. My lord, other sides are here, my lord. Collector, my lord, has given a notice. He was not happy with the valuation of certain properties. I am the owner. He has fixed a date for hearing, that is on 24th at 12:30, but did not give me a notice and I cannot attend. That is contrary to, my lord, section 47A(5). I want, my lord, only a hearing. That's all. Kindly, my lord, takes up this. I will not trouble your lordship, my lord.
Come tomorrow.
Well, the state is the.
I've served everybody.
Come tomorrow. Come tomorrow.
Yes, yes.
Tomorrow I can come, my lord, but because of the resolution, my lord, since my other side are here, allow me to participate.
24th is the date of hearing. We will pray for adjournment.
We don't want any deferment. I know that.
I will prefer an adjournment.
Come back on Monday.
No, my lord, we don't
Tomorrow
want any
and after
deferment.
tomorrow, there is some
Just give me, my lord,
difficulty.
10 minutes. If I can't
We'll
satisfy
prefer
you,
an adjournment. Their interests are protected.
The
We'll take
petitioner
adjournment.
has prayed for interim order in the present matter.
my lord, I
The
did not.
counsel for the respondents are also present, but due to paucity of time,
Yes.
it could not be taken of hearing.
No,
Counsel for the
tomorrow
petitioner submit that the hearing before the authority is fixed on 24th of April 2026.
Yes.
In view of the above, this court directs the authority to not to proceed, not
Yes.
to take, not to proceed with the proceeding till the next date of the order.
Yes.
My lord,
Next date of hearing.
My lord, my lord.
Let the matter remain in the list.
Yes,
my lord, may I pray for?
Tomorrow and day after tomorrow, I
One
believe they
indulgence,
will not be moving it.
But I know why the submission has been made, but today I will not.
I have passed now.
No, absolutely.
Take the hearing.
Yes.
But I tell your lordship, I will tell your lordship, my lord. I didn't make any prayer for court passed an order. Only
Yes.
thing, my lord, my lord, if lordship, my lord, fixes the matter, my lord, on Monday, any time convenient to the court. This is only prayer I have. Hear out the matter, my lord.
Lord,
See, today you are in 21.
24.
21.
The court has reached up till 19.
Yes, court will take up.
19.
Court
So
will take.
it automatically.
On Milord, on
Very well.
24th, they will give another date. So that may not be on Monday. It may be after some time. So
My lord,
So this court has
while
already
unless senior friend,
considered
yes,
it.
next date.
absolutely. So matter will.
I would say to take it up after the year, after the election.
No, I'm not protected at all.
Yes.
Matter could have taken up hearing.
Well, let them.
তারিখের পর নিক না 4 তারিখের পর নিক ইলেকশনের পরে নিক
Who is the concerned authority? Respond number?
My lord, the respondent number, my lord, 6.
Respond number 6.
No, let the matter remain in the.
Defer the hearing.
Yeah.
Hearing on 24th for 1 week.
Yes.
For
Lord,
1
may we come back
Lord,
after
may-
the 4th?
Let them
Because next week there are 3 days there will be no court.
Okay.
Next week 29th is the election.
defer the hearing till 10th April.
Yes, 10th May. Let us come back on 6th of May. Let us come back on 6th of May.
Lord, we will come back on.
Defer the hearing on
Yes.
10th of May 2026.
Yes.
List the matter on 6th of May within 5 matters.
My
In first
my-
five.
Mr. Dev got an interim order, my lord, at the end of the day.
No, I didn't get. My lord, very well. I would submit on the next day. That's a strategic call, my lord. I would make my submission on the next day.
Milord,
But let
may
it
I-
be, my lord, within
Milord-
first 5 matters on.
Yes, order দিয়েছে।
Milord, before the changeover, Milord, item number 104, Milord, my lord's list. My lord, you recollect, Milord, there was a call, Milord, direction, Milord, upon the authorities to form a neutral committee to assess my claim. Now, Milord, they had not formed the neutral committee and Milord dismissed my claim. Now, Milord, my lord has show cause them as to why a contempt rule will not be issued. This was the last order passed by your lordship. Now, they have filed an affidavit saying that they are willing to now form a committee. If my lord so directs. That's the only one formality remains. This is the last order. We have received the affidavit. We also given back the reply. Rejoinders are all complete. If you look only 1 minute, to form a neutral committee.
So what about the second? Whether show cause notice issued?
Yes, show cause notice issued. They had replied saying that there is a mistake on their part. So they are not.
Where's Mr. Burman?
I had requested, but anyway, he was waiting. It's been long.
What they are telling?
They are saying that they are now willing to form the committee.
So I am setting aside it.
So any day, now the situation is hot. Now before the these all things are done. Keeps it any day at the top so that it will take only 1 minute for your lordship. It's 104.
Do one thing. Let it be remain in the list. Let the fourth May complete. Then
no, my lord, will keep it after 4th May. Kindly
That's
keep it
why-
after 4th May. I'll give notice. I'll
That's-
kindly keep it at the top. Only 1 minute it will take for your lordship to form the committee. 200 crores are due and pending.
Item number?
104.
Item
Looking at
number-
item number.
Item number 104. Learned counsel for the, though the matter is listed as item number
104
of the today's list, but the matter could not be taken up for hearing. Police counsel for the petition has mentioned the matter and submit that after the issuance of the so-called notice by this court to the secretary to the Government of India, Ministry of Consumer Affairs, Food and Public Distribution, Department of Food and Public Distribution, the how you came to know?
They filed the so cause.
They filed the so
They filed the so cause. That's copy with us.
The
They are served on us.
the secretary has filed the so cause.
Served on us. Served on us. Served on us.
Filed the report by serving the copy to London counsel for the petitioner, informing that the ministry is ready to constitute a neutral committee.
Committee if the court so directs.
Neutral committee if this court so directs. Full stop. In view of the above, let the matter appear on 7th May 2026 within 10 matters under the heading urgent motion. Urgent motion 1.
Within the urgent motion. Instance can be 8.
Come on there.
My lord, may I be permitted to mention, my lord, item 31, my lord. This is the requisition of a vehicle of the school, my lord.
See, all the original sides are there.
My lord, just 1 minute. I will not stand in the way of the original side matters, my lord. Item 31 in your lordship's list.
You are from original.
That is why I would not. You can't. My lord, item 31, my lord, requisition of school vehicles. Your lordship had allowed our mentioning and said that your lordship will be able to take the matter today, my lord. It couldn't have been called. My lord, kindly take it up any day because Saturday we have to submit the vehicle. My lord, school. Your lordship has passed a similar order in the South Point matter, my lord.
That is challenged.
Not yet. I checked it today itself, my lord. Not challenged yet. No appeal, no stay. My lord, if your lordship can take it up anytime, my lord, on Friday, because my lord, tomorrow.
Your vehicle is to be.
Yes, my lord. Saturday we have to submit the vehicle.
Saturday is
25th.
25th.
We have given the notice also, my lord, that if the matter is not called, we'll be mentioning at the time of.
When it can be taken?
My lord,
24. 24 है ना?
Friday, my lord, if it
5 matter में कर दो.
deeply.
I'm sorry, but item
31.
Please to grant me leave, madam. So, my bank account have been completely.
Please wait till 4th. Let the election is over, then all the bank account will be released. Till the 4th, there is no bank account will not be released.
I run a store, my day-to-day account.
See, if I taken off the matter also, I cannot take the matter. I am not.
Please to grant me leave to file this matter and then.
Which number?
27.
27. Please wait. Come tomorrow. It will be taken.
Yes, tomorrow I'll try.
Yes, it will be reached.
I'm grateful, my lord. I'm grateful. I'm sorry for the inconvenience.
May I have your lordship's kindly to mention item number 187 of your lordship's list, my lord. My bank account has been frozen. This is a heavy matter. If it can be taken up any day, my lord, subject to your lordship's convenience.
After election.
After election, my lord fixes a date and a time. My lord. That is the only thing, because it is.
If the date and time, then come in the month of June.
Any day, my lord fixes.
Come
My lord.
after 4, you mention, I will take. Yes.
Item number 1 and item number 2.
Not time today.
Yeah, but, what your lordship can do is, there were 3 dates which your lordship had fixed. Out of that, I only got 1 date. Keeps fixes dates. I understand your lordship is under pressure. Any date convenient to your lordship.
Don't know when this matter.
I leave it to your lordship completely. Not your lordship had allotted 3 dates for me. I only got 45 minutes, but I'll try and finish it even quicker than that.
Last date.
But the problem that happens is not lack of continuity. That's all. That's why it becomes longer than it ought to. Not the lack of continuity. That's what becomes the problem.
That's the problem. That is the problem. That's why I'm fixing continuous, but it is not.
I know. But with your lordship's determination, it's difficult. But give me any 2.5 dates. Not whenever it's possible, and not.
खाली देखो 3 बजे कौन सा 16, 17, 18. PM में नहीं है 16, 18, 22 3 PM 16, 18 and 22 June continue 3 PM.
Very good.
18
And 22nd.
Though the matter is specially fixed today at 3 PM, 3 PM, 3:45, 3 PM, but due to positive time, matter could not be taken up a hearing. Let the matter appear on 16, 18 and 22 June at 3 PM as a specially fixed matter.
Obliged.
Grateful, my lord.
Incentive is exhausted.
Well, I don't want to open my mouth. It's entirely, my lord. I can see, my lord, your lordships, my lord.
Energy tabs are watering.
আপনি আসুন, please.
No, my lord, again, as
Mr.
Mr.
Shah has not entered into 34. He still is in
No, my
16.
lord, I have entered. Yesterday I have entered. And I am now, my lord, making my ground. But, my lord, it is a big matter. Very, very big matter. My lord, there is a lot at stake. I leave it to your lordship. I will be here whenever your lordship fixes it. My lord, that is my commitment to court.
Short possible date, lordships are only
Yes,
prayer.
I don't mind. Whenever your lordship can accommodate us, we are ready.
Hey, देखो 3:45 में हमारा May नहीं for June first week में because the May I may not be here.
No, my,
Because of May I may not be.
no, my lord, whenever your lordship can, my lord, early, later, whenever.
Only
Circuit.
request is of the shortest possible date.
Yes, which date you are telling? 9 June or दो 3 दिन दे दो.
If your lordship could have fixed it in circuit, we could have gone there.
Huh?
If your lordship could have fixed it in circuit, then we could have gone there.
There are other workload, but much more workload than this court.
Oh,
in the Jalpaiguri. That's why we are thinking.
Jalpaiguri is getting heavy day by day.
When last time I used to sit by 6 till 6:30.
My God.
Bail matters and all that.
Accessibility to বেড়ে গেলে যেটা হয়।
That's why the trade is intending to extend, but I don't know what will happen. Here also the problem is there. 6 judges are out, then
Yes.
principal bench is
Permanent.
कब है
মোটামুটি ওইদিকে এগোচ্ছে কিন্তু
June में 10, 11, 12.
What will you do with 6?
10, 11 and 12.
10th, 11th, 12th.
June 3:45.
Very good. 3:45, 10th, 11th, 12th.
Though the matter is specially fixed today at 3:45 PM, but due to paucity of time, matter could not be taken up a hearing. Let the matter appear on 10, 11, 10, 11 and 12, na?
Yes, my lord.
June
Very
2026
good.
at 3:45 PM.
I'll get to.
Yes.
Lordship, I appear for the intervener defendant from Bombay High Court.
Appearing for?
Intervener defendant. So your Lordship had given an order in the Calcutta High Court case.
There's no further question of intervention, my lord. If
Sir.
your lordship kindly takes page 88 of the application, it will all come back to your lordship.
I may be heard and they have not served anything to me.
88.
Page 88.
Nothing has been served on us.
My lord, if your lordship recollects,
My order.
yes, your lordship's order. My lord, this is that Calcutta Zoroastrian
Yes,
Party
yes, yes,
Trust, my lord,
yes.
where we had applied
Yes.
for leave to sell one
What
property.
has happened to this?
Now what had happened is, but this was your lordship's order after hearing the intervener, and thereafter from Bombay, your lordship passed an order. My lord, the operative portion of the order starts at page 94.
Paragraph 14.
Yes, my lord. Para 14 at page 94.
Yes.
My lord, your lordship said that the property is required to be valued and an attempt should be made to sell the property at the present market value. My lord, that is, my lord, para 14, page 94, clause C.
Obtain present market value of the property.
Correct. And then, my lord, kindly also consider D. The special officer shall make wide publication in the such and such 3 dailies, and the publication shall mention the basic price not less than the market value. And if any proposed purchaser come forward, 10%. Now, my lord, what had happened is the valuation report is at page 96, and at page 100, your lordship will find
Lordship,
the
nothing is
property
served
was
on us.
valued at rupees 7.83 crores, undisputed. Now, my lord, publications were made. Your lordship will find the publications. We've given the publications at page 103 to 105, 3 separate publication in 3 leading newspapers having wide circulations were made. No offers were received. My lord, the best offer that we received, your lordship will find, is from an individual, which is at page 106. He offered 6 crore. This is all that we received. Now, my lord, your lordship's order was of 2023. My lord, this is the position till date. This is what we have received. There's no other offer. So, my lord, a meeting was conducted.
So 1 crore 83 lakhs is less.
Yes.
Your Lordship, at least I may be served in
Yes.
the matter.
Now, my lord, what we do is that
No problem. Let me hear.
now, my lord, a meeting was conducted, and my lord, at page 107.
Yes.
The trustees have, my lord, resolved that this should be brought to the notice of the court. So, my lord, your lordship said market value reserve price. My lord, the second last paragraph your lordship will see, or in fact the second last paragraph at page 107. This is why we are before your lordship now.
Yes.
So now this is a catch-22 situation. Now, my lord, lordship kindly comes to the prayers. What are we seeking? Be it 7 of the prayers in the application. This is basically based on the principle that a bird in hand is worth 2 in a bush. So we've got an offer, so we cannot confirm the sale. He cannot proceed. The special officer cannot. Why? Because your lordship has said market value should be the basic price.
Yes. This is your prayer now. Yes. What is your objection?
Your Lordship, first and foremost, kindly see the title. Your Lordship judgment dated 14th.
Oh my God.
No, let us be fair.
Yes, please. Oh, yes, of course.
14th
You've
July
all along been fair.
2023. Kindly see the title. We were the interveners. Now they want a modification of the order. Fair enough. They want a modification. Your Lordship, all over India, we are fighting to save our trust properties. If they want a modification, nothing to laugh, sir. It is not easy to. I'm sorry for the Red Council. But the question is, if any modification is required, sir, are we not to be served? Any modification, in all fairness. And I will produce Supreme Court judgments on this issue.
Mr. Jaiwala, there is no problem. And court is here.
Yes, please.
No problem. Court will
We had
see to that.
objection to
But
overrule
what
করলাম না।
is your objection?
At least serve it to me, sir. Only after I read it, I can know what are the objections.
Okay.
Nothing has been served.
Mr.
Very well.
Let it, the application is served them. They have.
I just wanted to indicate to your lordship, my lord, what were the objections taken, how your lordship dealt with these objections, and then give us the leave.
Now, with regard to this.
Very well, we'll do that, we'll do that.
They are telling
My
that
lord,
they are having the persons to purchase a 780, no problem.
No problem. My lord, that is what we said. Kindly get us a buyer who will give you 10 crore, give us 10 crores.
Give the copy to them.
Very well, we'll give them. We'll give them.
The petitioner has filed the present application being GA1 of 2026, praying for modification of the order dated 14th July 2026 by fixing the sale price of reserve price of rupees 6 crores with respect of the property in question. The learned counsel for the petition submit that in terms of the order, the special officer has made the publication, has obtained the present market value from the competent authority, and as per the report, the present market value of the property is rupees 7 crore 83 lakhs. And after the receipt of the market value, the special officer has published the notice in the
Page 103.
for selling of the property, but none has come forward, and one of the person has made his offer for rupees 6 crore. According, the petitioner has filed present application for modification of the order dated 14 July 2026. Mr. Zaiwala, an advocate appearing for the intervener, submit that when the application being GA number.
It was ACR 4 of 2019.
When the application being ACR 4 of 2019 was taken up for hearing, this court has allowed the intervener to argue the matter, and accordingly the petitioner and prayed for direction upon the petitioner to serve the copy of the present application to the intervener. In view of the above, for the interest of justice, the petition is directed to serve the copy of this present application along with the documents to Mr. Zaiwala within a week from date. Let the matter.
Lord, if only one indulgence is if Mr. Zaiwala indicates his email ID, we'll
Your Khaitan and company used to send us all by email, so you are aware of it. You are aware of it.
Very well.
So only thing is from High Court is closing, Bombay High Court from 8th to 8th May, and from 4th I am not there. From 4th.
So kindly keep it on the 6th of May.
No, I'm not there. I'm traveling. So any date in June now.
So you keep traveling. So your trust cannot suffer because you are traveling.
There is a question of trust. You bought the property for 2.5 crores in 2008. Today, after 18 years, you want to sell it at that price? Even lower than the market value.
Why don't you get a buyer who will give us a better
I'm sorry.
When you will be available?
Sir, around 10 June onwards, any date. Give me, because High Court is closed.
I kindly appreciate this.
After 3 years, they don't
the
even
indulgence that is
sir, had they served it on me, I could have even replied. They tried to snatch an order from this court.
Let the matter appear.
10 June onwards, any date.
कोई बीच में कोई डेट है 345 का? 8 June है.
Sir, 9 June, 8th and 9th, 10 June onwards, I'm available any date. I will only, sir, be present because it's a public.
Mr. Zaiwala goes on long vacations. We are really
sir, Bombay High Court is on holiday. We get once a year holiday.
The Bombay High Court.
So what, so if the other courts function, will not work.
Mr. Zaiwala is from Bombay High Court.
Sir, it's a public issue matter. I am not personally involved. At the request of local parties, I have decided to defend the property. I do it all over India. It's not at one place only.
Yes, no problem.
Yeah, basically. That's good.
15 June.
My God, can you imagine?
15 June at 3:45
PM. I may be allowed to give a reply, possible. Written reply.
Is directed to file the reply, if any, within 2 weeks. Rejoinder, if any. Affidavit in opposition within 2 weeks. Reply, if any, within
2 weeks thereafter.
I'm obliged. Thank you, sir. I'm very much obliged.
Yes, next.
Next is my application for restoration. My lord, it is that matter where Mr. Milap Choradia is appearing. In fact, his GA4 was there. He was not moving. But my lord, on the submission of defendant number 2, the suit has been dismissed. In fact, I was last 2 years he is not moving his application. My suit summons have been served, everything has been done.
Nobody's appeared. What can be done?
That day it was.
My lord, I am
filed
strongly opposing that.
No, who is
Defendant number 2, I'm
you are appearing for the
defendant
Have you
number
served
2.
to Mr. Jai on this?
Yes, yes.
Where is the service?
It has been filed, my lord.
My lord, the affidavit is lot of false
No
statements are there.
service. No service.
No service.
Only the postal
The
receipt.
service.
Where is the track report?
The report has been.
The petitioner
Very
has
well, my
filed
lord,
present
kindly,
application being GA7 of 2026,
It has been served, my lord.
praying for recalling of the order dated
18th February
18th February 2026. 2026. Though the petitioner has filed the affidavit of service, but this court find that there is not track report to establish that the notice has been served to all the respondents. Accordingly, petitioner is directed to file a press affidavit of service on the next date fix. List the matter on 12th May.
12th May, my lord, if you can slightly indulge.
Then
please.
My
13th
land
May,
friend is
14th May.
opposing a restoration.
No, I'm
not
opposing it
claiming
very
that it is
strongly.
against me.
14th May.
Yeah.
You may oppose very strongly, but it is. My relief in the suit is not aimed against you.
12th, 13th, if we can avoid 12th and 13th May.
14th May.
Yes.
My relief in the suit is not aimed against him. It is against Mr. Chorodia.
Then delete
And
my
my lord,
name.
every day he is writing, my lord, he is sending an email every day, even today.
You pursue against him, just leave us out.
We have made him, this party,
Okay.
party
Next.
because publication have been made here.
May it please your lordship, my lord, I am appearing on behalf of the applicant petitioner in GA8. My lord, in this matter, it's a yes, it's a lot of history to this matter. My lord, parties have ultimately mutually settled, but my lord, the regular determination, we'll have to take steps before the regular determination, my lord, so that we bring the terms of settlement on board. Now, this matter, my lord, can be kept after the 15th of May, so that we take appropriate steps before the regular determination and then, my lord, withdraw this application.
As per the prayer made by the counsel for the plaintiff.
Yes, my lord.
Plaintiff, the case is adjourned. Let the matter appear on 22nd June 2026.
My lord, let it be in the month of May, my lord. Everything is going to be settled within May itself. In fact, we have vacated the premises.
Settle you mentioned.
Well, any day, 15th of May or 16th of May.
Let the matter appear on. Let the matter appear on.
It'll just be a minute of your lordship's time.
On 18th May 2026.
I'm deeply obliged.
Next.
My lord, I'm appearing for the petitioner in this matter.
Yes.
My lord, I'm led by Mr. Arindam Banerjee.
Kindly
take up this matter on Friday.
Friday.
My lord, may I have the leave of the lordship to file this opposition, my lord?
File it.
Yes.
I have served copy.
Yes, but they have not given reply.
Will not file reply.
I will file reply by my lord.
They must give me reply.
You are appearing for?
I am for the petitioner contempt, plaintiff number 1.
Plaintiff has filed affidavit in opposition to GA4 of 2026 after serving the copy to the land counsel for the defendant. The defendant's press for filed reply. Let the reply be filed within
1 week, my lord.
1 week. List the matter on 12th May. Next. होता है हमारा लोग को होता है Yes, item number 8. Not today. No, not today.
Not 13 and 14. Just my lord, some technical order I am seeking. 13 and 14, two connected matters, my lord, probate matters. As per your lordship's direction on the last passed by your lordship, testamentary number has been already deputed in this to assigned. And my lord, I'm seeking that your lordship may kindly grant me liberty to disclose the documents. In item number 13, I am the plaintiff. In the 14, I am the defendant.
Where is the defendants?
That is the problem, my lord. They are not
coming. What can be done? Record an order 13, 14.
I'll file the issues also on the next day, my lord.
Learned counsel appearing for TS 13.
Yes, my lord, I am for the plaintiff in the, my lord, PLA 23.
TS number.
That's item number 13, I am for the plaintiff.
You are the, that's right, the counsel for the plaintiff in TS number 13 of 2026 submits that the defendants already filed the written statement and prays for a direction for discovery and inspection of the document. Full stop. In view of the above, what about the TS 13?
That has been also there. I have filed long back and it has been numbered as a testamentary suit.
And in TS number 10 of 2026, also the defendant has filed the written statement. In view of the above, in both the cases, parties are directed to complete the discovery and inspection of the document within 3 weeks. Full stop. Affidavit of document be filed within a week thereafter. List the matter on full stop. In the meantime, the parties are also directed to exchange the affidavits. List the matter on 4 weeks. List the matter. This is the matter on 9th June 2026 for framing of issues.
Grateful, my lord.
The plaintiff in TS 10 of 2026 and 13 of 2026 is directed to communicate the order to the defendants.
I'm grateful, my lord. I'm grateful.
पेपर पे लिख लेना
একটু 64 65 to কে বলবে অ্যাপিলেট
16 তারিখে মেনশনটা আছে তোমার কাছে 16 তারিখের
থ্যাংক ইউ